Phrase admission matters may
Give all the members. Give all the members. Give the memos.
First admission item number 1.
I have for amendment and I have a glance at the last order. Council for the status.
maybe allowed.
Yes, brother. How many members? As per the schedule.
1 of 2025. Has been filed for amendment of reproduction. It is stated that certain have been inadvertently omitted. Omitted while filing the reproduction. Accordingly, as per schedule, so paragraph 6A is spread to be incorporated in the restriction. Mr. Sanjay Rath, additional government advocate, have no objection for allowing the IA. Accordingly, the IA stands alone, and the letter counsel for the petitioner is directed to file consolidated restriction. They're within 3 working days. Matter to appear
Within 15 days, says. Order 6 rule 18 says 15 days.
15 days. 15 days. 14 days. 14 days.
6 and 7 also.
7.
6 of
Oh, 6. Schedule, as per schedule.
Item number 2.
What's your instruction?
Now, in item number 2, the appeal has been admitted on 29/7 and has been posted to 19/8. Next is given is
Let this matter be also listed. So there is already an interim order which is passed in the writ petition. So let both be taken up together. So it has been brought to our notice that regulation being WP within bracket C number. Sorry, other writ appeal being WA number
petition WPC number
Acha.
20153.
53 of 2025. But that was disposed of.
That was disposed of, my lord.
Then
And my lord, liberty was given to the petitioner in that case to file appeal before the sub-collector.
correct.
That appeal has been admitted on 29/7 and the next date has been fixed to 19/8.
Oh. Lako, it was noticed on the last occasion that some of the
But the direction of the government will have also given that will be taken on record.
Oh, I have already
Published.
instruction be taken on record.
Item number 5.
Pardon, Your Lordship, I'm appearing for the caveator on VC Miller.
Illegal nomination by Mr. State.
What?
And there is the tender notice issued by the opposite party. And the petitioner was a successful bidder.
I will serve. He has filed a caveat. You have been received?
Yes, Miller, I've received the copy of the statement.
Why the bank guarantee is not released?
Either
Miller,
they have released or they have paid to the
The,
salary of the
or the, whatever, the wages of the skilled workers?
My Lord, if Your Lordships allow me, I'll just take Your Lordships. My Lord, may kindly see the show cause notice as Annexure 4.
No.
My Lord, our allegation is all
Where?
documents. My
What
Lord,
notice that?
this Annexure 4, my Lord, page 22.
Yes. Yes.
My Lord, may kindly come to.
Just 1 minute. Yes.
Yes, Your Lordship. My Lord, 24 is the relevant question. My Lord, they had got 22 people as skilled laborers. The tender document said give us two
Paragraph,
things.
paragraph,
Their educational
paragraph.
Well, there is no paragraph number, my lord. If Your Lordship has page 24, there is a table. And may I take Your Lordship just before the paragraph, just before the table? Your Lordship has page 24.
Yes.
Well, let me kindly see the second paragraph. In view of the above provision, the experience certificate submitted in respect to the following 11 workers were verified by this office and observations with regard as submitted in table of form. For the 6 employees, let me kindly see the observation. Having found that the experience certificate issued by one of your sister organization, where you are the signatory as the proprietor, on cross-verification from Messrs. IFCO, it was ascertained and confirmed that out of these 7 persons, no one was working in IFCO railway siding at that time. Number 2, it is also revealed from the character certificate issued by the respective concerned district police headquarters. Verifying the antecedents of the last 2 decades, at no point of time they were residing in Paradip, place of work mentioned in their experience certificate. Rather, it is confirmed that they were staying at their respective native place as mentioned in their character certificate verified by the concerned police department. 3. Therefore, the experience certificate issued by firm are not only ingenuine, but appears to be forged and manufactured. This is for the first 6 people, Madam. Then come to the 7th person. 7th person, Madam, may kindly see para number 6 in page 25 at the last column. Hence, it is difficult to substantiate that the workman was simultaneously pursuing a study at Devi Private ITI and where he had passed the examination in July 2019 and working in Paradip under your sister organization. So it is overlapping. Period of the study coincides with the period of experience certificate, hence appears to be forged and manufactured. 8th person. The working period mentioned in the experience certificate in the incumbent coincides with the duration of the educational period. Same thing. Number 2, the workman was pursuing his higher secondary commerce study under Sri Mauja Bhanja Mahavidyalaya, Jagatsinghpur, and passed the annual examination held in March 2018. Well, again, their experience and educational certificate coincided. Number 9 and Miller, that the period mentioned in the experience certificate does not match with the license period. So, Miller, in the experience period, they said that he was working in a particular company. We found out that the time period.
Then, so far as
So,
the 11 persons are concerned.
Yes, Miller.
There may
So
be
total,
some
Miller,
difficulty. But so far, so far as the other employees are concerned, there are 21
absolutely
skilled workers.
Kindly,
what about
that total 22. May kindly see the reply at page 20. I'll tell you, Lordship. May kindly come to the reply. What they are saying is out of 22 we gave for 11. The other 11 are interested to give you. May kindly have page 28. Their reply.
20.
Annexure 5. 28. 28. Annexure 5. Yes, Your Lordship. That's the reply to the show cause notice. Letter dated 29/6/2025. I'll only take your Lordship to para number 1. It is a fact that senior traffic manager has sought at the information on the ground of your experience, skilled and educational qualifications, skilled manpower workers applied by us in 22 numbers. out of which 11 numbers workers are employed skilled workers in Zetiki till date, and employees list which is placed before us, your good officer accepted this and so and so and so. My lord, two. My lord, may see. My lord, so only for 11 they have given. The other 11, my lord, they have not at all given the required educational qualification and the antecedents, which are required for us to cross-check. Now, my lord, that is why when they have not replied to our contention, which we have raised, saying that it is fraudulent and all that, now, my lord, we have terminated it. saying that
Terminated the contract. They are
Yes, my lord.
terminated the
Termination.
contract.
Yes, my lord. Terminated at contract at Annexure 6. Now, my lord, unfortunately, my lord, they have not given the tender conditions. The tender conditions is not there, so I can't take your lordship. If your lordship gives me time, I'll file everything. But, my lord,
So file your reply. Counter
my lord. Yes, your lordship.
after. Nothing.
Application in the meanwhile, they have already issued another tender notice.
They let them. If this is correct, then sorry. I'm the last person to know. How can you employ a person still pursuing his study?
So far, the 11 persons were eligible.
Sorry, why you have? Falsa uno is a falsa omnibus. Why not that maxim should apply? Why not?
They will get the skilled laborers.
Sorry,
Certificate issued.
this can't be. You are. First prayer is very interesting. You have cows, bank release, salary release, and this which should be the first prayer. You have did it in a second way, quashing off that particular order. What is this? How can you engage a person who is also pursuing his studies?
11 persons are skilled workers. That skilled certificates have been issued by the registered.
They have said that out of these 11 workers, 2 of them appears to be a student. They are pursuing their study. They are appearing in the school. They are attending the school, appearing in the examinations. How can they simultaneously work?
At the time of their working period from 6 to 2025,
You explain your conduct. This cannot be done. If that is where it's not a so simple matter, where we can take a most lenient view that a workers not be deprived of their wages. We know, but we can't in this case. If you play tricks, then it's a very difficult situation. File your opposition. Counter. Within 3 weeks, rejoinder 1 week, to appear after 4 weeks. Give it time.
Item number 6.
Yes.
The substance to my allegations not to support my contents. I filed additional affidavit in this case, lordship, explaining lordship all the details, and lordship kindly come to my affidavit. In para 2 lordship, from para 2 I have taken. So my affidavit, last occasion I have filled the affidavit. Until 845 lordship affidavit.
What is the matter about?
Let's be here, let's see, in fact, the petition of one of the participants. His bid was rejected on the self-same term, the single bid of the allowed. And lordship, despite his disqualification, and I filed for the Kurkish lordship, what is the entire the sequence of events, they did not grant me documents. Then I approached this honorable court, and this honorable court directed to file an appeal lordship. My appeal was somehow lordship on merits was allowed, but on the ground of the jurisdiction, it was dismissed. Then I preferred appeal, read petition before this honorable court, while remanding back the appeal to consider appeal address on the ground of jurisdiction. The appellate authority has rejected my appeal on the ground of limitation. That is the entire subject matter. And let's see.
Firstly, it was decided on merit,
Merit, yes.
but later on that was set aside
Set aside.
and then reverted back. And then while reverting back on merit, he found in your favor, but on the ground of limitation, he has rejected.
He has not gone through the merit.
Okay, he has not.
Only on the-
Second time, he did not.
The ground of limitation only.
And first time, the merit was in your
Merit
favor,
was-
but want of jurisdiction.
Jurisdiction. The applicant para in us. Appeal to the entire delay, which was court. It was never attributed to the petitioner. From the day one, I had applied for certificate copy. And despite my several efforts, lastly, I approached before the appellate authority. Then on his direction, only certificates could be, the entire certified copies could be granted after 9 months. Lordship. That's why delay caused to approach before this honorable court. And then I preferred the appeal. Lordship. Lordship, can come to para 2, I have explained the same additional affidavit. Lordship. That's a good. The deduction notice published on 4th relative, published on by opposite part number 4, involving applicants for settlement of Tetarkala sandbed quarry under Virumatrapur Tahsil of Sundargarh district, and the petitioner submitted his application on 21/3/22 along with the opposite part number 5. According, there are only 2 participants, and the petitioners bid on the ground of non-submission of proof of earnest money 21/23. Despite submission of same with proof of the bid of opposite part number 5 accepted and declared as a highest bidder 22/2. Despite non-deposit of treasury challenge of the GST registration and single bidder, which mandates under the rules in accepting refund amount royalty in rule 27(7) of the rules beyond 15 days, that is 22, by your checks in contact with the provision of rules followed by agreements on 15/7/22. Then the aforesaid sequence of events are without knowledge of the petitioner, and the aforesaid developments are sequence of events were never communicated to the petitioner at any point of time. Then para 4, Lordship. And hence to ascertain the.
No, I have read up to paragraph.
Lordship. No. This para 4 is sufficient. Lordship. Para 4, Lordship.
Yes, what you say, madam?
When I refer to annexure A/1 series at page number 5, my lords,
Is number?
5 of this affidavit,
Okay.
my lords, the date of application is 8/3/2021, page number 5.
22.
Yes.
Sorry, 8/3/2022.
Where do I get it?
The form of applicant of for the.
Yes, now number and date of application. 22.
Yes, my lords. And serial number 4, my lords. What is asked is specification of paper for which copy is required.
No, certified copy of the entire order sheet, bid sheet, Form F, intimation of successful bidder, first and second, solvency certificate, treasury challan, all bidders for sources in respect of auction, such and such. So they wanted the entire file.
Held on 20/01/2022, my lords.
Yes.
The present auction is dated 4/3/2022. It is a different auction date, my lords.
Was there any auction on that day?
That effect, my lords, I have asked for instructions, my lords.
I'm simply asking whether there was any other auction
Because in
on a
the,
particular day. 20th January 2022, there was any auction by this, the auction notice number such and such.
yes, my lord, there was an auction, but it was not.
By with this notice,
And here, my lord, at page number 30 of the writ petition, my lords, annexure 2, my lord.
what?
Page number 30, annexure 2 to the writ petition, my lords. But, my lord, I could not understand the question.
there may be a ministerial or typographical error. But if those error can be reasonably weed out, then in that event, whether you will go by the mistake or you will go by the content.
Yes, my lords. To that effect, my lords.
So that is the first thing is that if let us examine. You know what is called.
Yes, my lords. And
I do not know the content. I can't read.
specific.
Anyhow, what is the auction number?
560.
568 of 4/3/2022. Now, what is this?
In brief, if I may mention, it's.
Yes, please.
So last date was 21/3.
Yes, my lords. And the opening of the bid was 12/15 on the same day.
If
Where is the serial number 1?
No, there is written. It fails.
Yes,
Then 28/3/2022 or thereafter, if that is also could not happen. That could not happen, then it is third time.
Yes.
It can be 4th April
yes, my lords.
2020.
In this matter, it was opened on 21/3/2022. It is clear from the order sheet at page number 36, my lords. And both the bidders were present on that date, my lords. 21/3/2020.
No, I understand. What you supplied, let us go. He says that subsequently the certified copy was supplied.
Yes, my lords.
What certificate you supplied?
That is also next I wanted to refer to, my lords. Para 6, where he refers to supply of certified copy. What is annexed is appeal records, my lords. Para 6 of the affidavit, if I may read this paragraph, my lords, that only after interference of sub-collector for the certified copies they get ready by 1911, and in the month of January 2023, the copies were handed over. Copies of order along with copies of relevant documents are annexed to Annexure A/3 series.
Now, A/3 series show us that what is the date?
Yes, my lord. Annexure A/3 series starts
Yes.
on page number 10, my lords.
10.
Yes, my lord.
Okay.
And next is the appeal records, my lords. Appeal before the sub-collector.
Madam, when the certified copy is given, then what is the certified copy which is given to him?
This, my lords, page number 11 onwards, if I see, my lords, it is the form of the appeal. Thereafter, the appeal which.
Page number?
11.
It starts from 10.
It starts from 10, my lords.
1911/22.
Yes.
Page number 11 is the form of appeal. Page number 17 onwards is the appeal.
So the form of appeal is against what? Against the order passed on 6 March.
This is after a year, my lords.
No, form of appeal. I just wanted against which order?
6/3/2000. 6/3.
Against the order passed on such and such by the Honorable High Court in such and such. What is, I do not know. Certified copy is enclosed. Then what certified copy was enclosed? Page?
My lords, the appeal paper book starts from, appeal starts from page number.
This appeal is filed also
Filed.
to direction of this court.
After the direction of.
So this court directed on 6/3/2023. So certified copy of that order was received, is claimed to have been received by him on 15/3/2023.
Well, it's here the whole idea was.
No, what she tried to create a confusion everywhere. She says that what was an application for certified copy? The application for certified copy was in relation to another auction notice, which was there in January.
Yes.
Now, this is an auction which was scheduled in March. So this is what she says, that this story of certified copy is absolutely a farcical approach she wanted. Let us see, when an appeal was filed, then what was a certified copy which was annexed? Let us see.
Add one more.
Just,
thing.
I will come,
Yes.
madam. You have to face a lot of questions. You are taking a plea, wonderful, no doubt about it, on a factual matrix. Let us see the reality. So where is the appeal? Form of an appeal is annexure A.
You have the records of appeal.
And no, this is the annexure A before the sub-collector. And the appeal is
Yes, 15 principle.
14 of 2020.
no, just
Appeal is,
yes, they have filed an appeal at page 4, if you come to their additional affidavit. Paragraph 5.
Appeal memo, page 15.
I am looking at your additional affidavit,
Yes.
internal page 4, paragraph 5 and 6 are the reflection of that
Yes.
particular auction of 4/3/2022. And then you say the true copy of the certified copy, annexure 4, there too. Now annexure 4, annexure 4. This is the annexure 4 at page 31 or what? 31? Whatever. So that this is correct. When he has applied for certificate copy of this.
Alex, two things I just want to.
You read the entire brief as.
Yes, my lord. Yes.
You have read some portion.
No, my lords, only two.
You are raising an issue. When an appeal is filed, this appeal is filed against what order?
Order of selection, sir. Selection.
Order of the Tehsildar.
Yes, my lords.
The order of the Tehsildar was passed in relation to an action which was reading.
Yes, my lord. No, my lords.
So if we can file an appeal against that, that shows that certified copies was also next. So that was in relation to an auction held in March. So if he has wrongly written something around 20th of January or such, but his certificate copy was issued by your dealer, actually, because there was no auction which was held on 20th of January.
Yes, my lords.
It was held on 21st of March.
Yes, ma'am.
So they gave the certified copy of the entire order sheet concerning that auction of 21st. In the plea that there was a disparity or mistake in the application for certified copy.
No, my lords, two submission, my lords. Respectfully, two submission. One, dated 4/3/2022 specifically mentioned that the last date for submission of bid is 21/3/2022. And at 12/15, the bids will open. So the date of knowledge that it is supposed to be open on 21/3 was well known with the petitioner, my lords. Here, the reference is made to an earlier auction, my lords. Because whether it was held or not held, that is a different question, my lords. But my lords, 1 minute, my lords, if I may just complete, my lords.
You need a season. You have to be seasoned.
Yes, my lords.
When you argue, you have to be seasoned.
Yes, my lords. Also, my lords, 21/2022, when the order was passed before the Tehsildar, the petitioner was present, my lords. So the date of knowledge goes back to 21/3/2022. My lords, I understand the provision of section rule 46 talks about communication of the order, my lords. But here 21/3/2022 was well.
First, you cannot club it together. That's the whole, I would say that there is a lack of dichotomy between these two. You are taking a plea that 20th January was the another option, but he was concerned about that option. He was not concerned about the March option, which appears from the Winnie record is wrong.
My second.
Only thing is that there was a mistake in referring a particular date. That mistake does not take away as a substantial or a legal right. This plea also cannot be accepted because it appears from the appellate court's order. The certified copy was issued on the basis of that application in relation to the held in March. How can an authority issue a certified copy of an auction which was held in March when he applied for a certified copy of an auction held in January? He cannot. If it is held in January, the document would have been different. That shows that the authorities were conscious that this mistake is very ministerial in nature, not substantive mistake to take away the right. So they treat it as a certified copy for an auction held in the month of March. That was given. So the first point which you take against you. The second point which you say that 21st March was the date when the auction was open or the bid was open.
Yes.
Now you say that they had a knowledge. Now the two things. One is the knowledge of opening of the bid and a communication of a decision. Whether you can club it together, both are the one concept.
Yes, sir. If
You can, let me give you an example why I say you applied to appear in the examination. The examination interview was conducted on a particular day. You participated, no doubt. But the result, that what is the outcome was not communicated to you. When your right would accrue to challenge the particular decision, when the decision is communicated to you, that would be the date when you come to know that this decision may be taken on that date, but may not be open. You are not there. Nobody was there. It may have opened. Yes, we have found this is what it has come. Decision will be taken. And then they got together, evaluated, and took a decision subsequent to thereto. And then the communication has to be made. And the limitation will run from the date of the communication. Why the legislatures have used the word, they know your functioning very well. How you function.
yes, my lords, to that effect, my lords, if I may submit, my lords. First, my lords, if I may refer to page number 36, order 21/3/2022, page number 36 of the writ petition.
Yes.
CR is put up today on the scheduled time fixed. The tenders of
Yes, sir.
case records.
I'm not very much accustomed with the abbreviations. Read full.
Case records is put up today on the scheduled date and time fixed. The tender box is open. Page number 36 of the writ petition, madam.
Read.
Annexure 3 series.
Yes. I was making probably the same thing.
Case puts up today on the scheduled date and the time fixed, the tender box is open in the presence of the participants.
Yes.
The case record is put up today on the scheduled date and time fixed, the tender box is opened in the presence of the participant. And it is found that two numbers of lease application filed on the sealed cover evolves by the applicant for so and so sand bid, detail mentioned so and so. And here, this is the order which was passed in the presence of both the bidders. This I can also correlate to the impugned order at page number 7. Let's before that, only one thing under the rules, the communication is to be made only to the successful bidder as per rule 27(6), my lords. Rule 27(6) of Odisha Minor Mineral Concession Rule. 7(6). Yes, my lord.
Selected bidder.
Yes, my lord. Only to the selected bidder.
There is a right of the
46, my lords.
The legislatures were not really intelligent one when they incorporated this. That's what is the, if the communication is only given to a successful bidder only, then the right of appeal under 46 from the date of the communication, farcical approach. If how the successful bidder and why the successful bidder will prefer an appeal, he is the successful bidder, beneficiary of the order. I will go. He does not qualify that expression agreed. He's not. You have declared him successful, you have granted a release, then why from that communication he will go for an appeal? This is
Rule 6 has to be read in harmony with sub-rule 7 for its subsequent course action to be taken by the successful bidder.
Yes, my lord.
So 6 has to be in coherence with 7. So that is for the purpose of successful bidder. But this rule has nothing to do with rules 46. Rule 46 says communication. So unless every person, as his lordship has said, that it has to be communicated to everybody. To know that who is successful and who why he could not be successful. That is why.
Hence the date of
approach.
hence the date of knowledge becomes very important in this matter, my lords.
whether the date of knowledge, the date of communication are two synonymous.
My lords, it's not synonymous.
Just asking.
My lords, in such a case, my lords, when the bids
There are a lot of judgment of the Supreme Court that right notice is there, then the procedure has to be strictly followed. You cannot borrow the purpose of interpretation.
Application is 46(1).
Very interesting,
my lords,
interesting way of position of law.
my lords, page number 60, if I may refer to, my lords, the impugned order, my lords. What was
I'm asking, madam, very simple thing. You are referring 27(6). That's a communication to a successful bidder. And when you are referring rule 46, which is the right of appeal provided to any person agreed. And then when the limitation would run from the date of communication, then what it follows? That communication to a successful bidder, application referred here.
No, my lords, I understand the communication will not be as referred to the petition. Then, my lords, the affidavit comes into the picture, my lords. The affidavit specifically mentioned that the date of application is 8/3/2022, my lords. That is prior to the opening of the bid, my lords. Then, and on 21/3/2022, petitioner already had knowledge. He willfully or whatever.
But honest, is it okay that you should get a certified copy?
My lords, then it will stall the process.
Suppose 9 and suppose 11.
My lords, then it will
What
automatically.
happens to suppose 11?
My lords, that, my
How
lords,
how will you know
my lords,
that
that
he is the second here? If you don't communicate,
as per the rules,
Madam,
the communication only has.
first successful bidder is communicated for taking further action under subsection sub-rule 7 pursuant to sub-rule 6. Then if he fails, then how can this percolate to sub-rule 11
My lords, then
automatically
then
when he doesn't have the knowledge?
it will be my lords. My lords,
So who will be aggrieved?
my lords,
Can this second successful bidder be aggrieved?
my lords, the
So-
successful bidder was already aggrieved on 21/3/2022, my lords. He already had knowledge that he's a successful bidder,
So-
my lords.
What will he do? With the knowledge, what will he do?
He could have applied for an
Why?
certified copy at
That
that
is the provision.
certified copy. There is no provision, my lords, under the
So-
rules. The communication
So by
only has to be.
communication, you should have said in the 46, saying that enclosing certified copy, you will file a bill. Where is that modality? It is a communication. What do you mean by communication?
My lords, to that respect, I understand, my lords. Then, my lords, for example, if the unsuccessful bidder comes up
What
over
is
here
authority?
and applies
Yes,
for
yes,
certified
yes.
copy, then it will entirely stall the process, my lords. My lords, for example, if the unsuccessful bidder applies for certified copy after 1 year and he comes to know that this is the reason, then he prefers an appeal, then it will substantially stall the process, my lords. Because
Sorry, I'm giving you a judgment is pronounced in the open court is to the knowledge of it.
yes, my lords.
And then the certified copy is applied.
Yes, my lords.
applied.
The certified copy was applied substantial after that period, my lords.
Question is that he has applied a certificate copy of the entire proceeding. And he applied to give it, where is the difference? And the appellate court would have rejected the appeal on the ground that it does not proceed with the copy of the order. Certified copy was made up, was applied in prior to 21/3, as you say. How can you give a certified copy of the order subsequent thereto?
My lords, to that effect, my lords, what is
The
applied,
order which is non-existent. It has not seen the birth. Can you supply a certified copy
my
without
lords,
any application?
my lords, as per the amendments made in para 6, correlation with annexure A/3, what is supplied or annexed in this document
The
is
internal order sheet including the order of 21
no,
March.
my lords, no, my
What
lords.
are you talking about? Your order appellate courts proceeds on that basis that he has challenged the order dated 21/3.
My lords, the
What
audit.
are you talking about?
Audit.
If you come to this order of the appellate authority,
Yes,
I
my
am
lords.
reading this paragraph, this order, sorry, not paragraph, the order of the appellate authority. I think the final order which is passed, you come to page 41 of the additional affidavit, order dated 13/8/2024, passed by the appellate authority. Recording the entire thing. If you come, peruse the petition. Have you seen?
Yes,
Please come to page 41. There's an order sheet of the appellate authority,
Yes, my lords.
13A,
Yes, my lords.
second paragraph, peruse the petition.
Yes, my lords.
LCR received,
Yes, my lords.
document verified. During verification, following formalities have been maintained in the earlier case. Auction was held on 21/3. submitted on such and such. He revealed from the order that the additional charges less has also been paid. Then he knew that what is the challenge made. And if the challenge is of 21.3, then what to do?
But that is respectfully my submission. This document does not contain 21/3/2022, my lords.
What?
This annexure 3, A by 3 does not contain A by order dated 21/3/2022.
What?
Because my lord,
Then this order you accepted, if you come to page 43, the last paragraph, the penultimate paragraph, what the appellate authority hears.
it's the language of para 5 and 6 of the affidavit.
That's a really narration of the facts which emerges from the record of the appellate authority.
Narration of the fact when the order was communicated, my lords.
It is not on the ground of jurisdiction, please come, that's why I am saying the first order you did not challenge it. It's an ultimate paragraph. What it says.
As the irregularities have been made by the lessee as well as the tehsildar, there is no scope to consider the prayer of the appellate due to lack of jurisdiction.
So what does it mean?
Yes, my lord. My lord.
What does it mean?
This order was subsequently challenged, and what the Honorable High Court held that to since all the parties are appearing before the court, this court, in order to avoid further delay, directs the party to appear before the Deputy Director Mines Sundargarh to receive further instruction in the matter. Endeavor shall be made for early disposal of the appeal in accordance with law.
Correct. So that is why, because the court finds in just paragraph above that irregularities. That how it has gone, please consider, in considering the limited prayer of the appellant, going through the documents in LCR, guidelines in the rules, deficiencies described, this court comes to the conclusion that the competent authority has not rightly observed the formalities as per the rules before going for selection of a successful bidder. At the same time, the H1 highest bidder, now Lacey, has also violated the very basic principles framed for the auction process. If that is the categorical finding, and then lack of jurisdiction, the High Court says you can't, you decide.
In accordance.
God, this finding remain.
Well, it's, if the
If
finding.
this finding remains, can it be reopened by a same authority? First principle of law.
Well, it's, this order is without jurisdiction.
I'm talking about the very first principles of law,
Yes, ma'am.
which is the fundamental principles of law. When it begins.
Well, it's respectfully, this order is without jurisdiction that as has been held by the.
It's not. It's saying that this order, the authority says that I have no jurisdiction is wrong. We have jurisdiction.
No, my lord, that's what Honorable High Court has
High
said.
Court says that you decide. I hold the jurisdiction is reviewed.
No, my lords. The sub-collector had passed this order, my lords. Subsequently, this order was challenged before the High Court, and the High Court also did the sub-collector.
Challenge.
My lord, petitioner challenged.
You did not.
No, my lord, petitioner challenged.
You did not challenge this portion of the order.
No,
Where it is held that the H1 is now, Lacey has also violated
yes,
the very basic principles.
that we have not challenged. No. Petitioner,
Nor you find any counter.
it was argued on point of law only, my lord. It was argued on point of law, my lords. Whether a counter was filed or not in that matter, my lords,
Counter means did not understand what I mean. Sorry, that's my, I use the half word. Sounds a claim. It's a presentation of this presentation. Appeal is not subjection, and the suit to original proceeding is the counter. So what you even do one, I think what is there? Previously, so decree now is a validity by 2002 judgment. That's a form of a relief. So that's
only point, my lords, I was trying to make That's the only point I was trying to make in the affidavit. What is tried to be portrayed is that the application was made on 8/3/2022. Thereafter, multiple times it was approach, and thereafter on 1911, these documents were given to the petitioner.
How we know.
Yes.
When a provision of the appeal, of the remedy of an appeal is provided in the statute, then what should be the approach of the court in interpreting the words which are used in that particular section? Should it be a purposive construction? Should it be a literal construction? Or
Because it's a special statute, my lords, I understand it should be literal interpretations.
literal?
Yes, my lords.
So if it is a literal interpretation, there's an interpretation which really frustrates the very purpose. Should that interpretation be accepted by the court? Which really takes away the right of an appeal. Can the court take up that special statute? What the hidden rule says about it? You understand? Hidden rule of interpretation, what it says. HAYDEN.
Problem of mischief. Suppress the problem and advance the remedy.
That is what I'm saying. The mischief rule. What should be?
Still has to be
Remedy. Yes, my lords.
by way of interpretation.
Interpretation.
Amendment.
Yes, my lords.
No. Throw him out on merit. There's no nuance. We have no nothing on that. But don't throw him on the technical.
Yes, sir.
Throw him. He has no merit, nothing of that kind for us. But don't throw him on the point of view. Because this was the appeal which was registered and continued.
Yes, yes, ma'am.
Who has passed the order, final order?
Mining of.
Mining official, deputy director, no, deputy director mines, come controlling authority.
Where
Lordship.
is that order?
Lordship. It starts from the page
58.
58, Lordship, and
Of the
62,
writ,
62, Lordship, that
of the writ,
Yes, my lords.
9/6/2025, Lordship. Very close.
it's interesting. Have you noticed this? The RA appeal number is one and the same, which was registered by the sub. That is what. There is no, have you made a list of deeds?
Lordship, that is. B, Lordship, Alex.
Just below synopsis. Very cryptic, kind of a list of dates. There is a, can you give me a page number?
Yes.
What is the page number of option?
Page number 30.
Page number?
30. 30.
30. What is your date of the 2021 please?
That is my lords, page number 36.
36.
Where is that 8/6/2022? Chapter number 1276, that is the party should have.
Page 40. Lordship.
Page
40. 40.
These executed, and you have given the rules,
Yes, Lordship. Annexure 4, page 45.
45.
45. Lordship.
And then now there is a missing one. That you challenge the order, what? 12/5/2025, there is the order. But I find there is a missing link.
Lordship.
Between 15/7/2022 to 12/5/2025. 3 years, 3 years. Something happened in between 3 years.
Lordship.
What has happened?
My lords, if I may
Lordship, the
refer,
person has Lordship HD agreement and now Lordship mission.
my lords, page number 59 is the history.
You have not taken any step.
No, Lordship. Immediately I have approached this Honorable Court, Lordship.
Oh, where is that? That is what I really wanted. You are not. There is a complete gap in the list of dates.
Lordship, that is page 11, Lordship. Page 11 of rate application. Para 13, Lordship. Page 11, para 30.
So this is of 2024. You approach the court.
Lordship.
Where is the order of 12/5?
Lordship, I have quoted Lordship, para 13, Lordship.
No, this is you are assessing an order of 13th August 2024.
So, sorry,
What
Lordship.
is that order of 24? That's what I
Lordship-
am asking.
Lordship, para 5, Lordship. Page 5, para 3, Lordship. Page 5, para 3, Lordship.
You have that order copy.
Second order, my lords, I have.
I have quoted that order.
That is quoted in the writ petition.
Yes, I have quoted both the orders. I have quoted.
And then on 6/3, this was given. Then what happened on 6/3?
Lordship, then outcome, Lordship, 13/8/24, Lordship, the whatever the appellate authority. 24. Page 27.
When the appeal was filed, it was filed on.
Appeal, Lordship, appeal filed on 6/3/2023, Lordship. Sorry, Lordship, that is the
No, 6/3
23.
of the High Court.
Lordship.
When the appeal was filed.
23/3/2023, Lordship. 23/3/2023.
23.
3/2023.
Is what I say that you're like that. I have to find out what.
Sorry,
is
sir,
the-
extreme sorry, Lordship, because
Just imagine, this is what the.
extreme sorry, Lordship. Extreme sorry.
Was an order of 13.
8/24, Lordship.
And against this order,
I approach this honorable Lordship.
You approve this one. What's more key?
Lordship, that is 12/25 disposability application, Lordship.
Where is the?
Para 13, Lordship, para 13, page 11, para 13, Lordship.
Yes. So it was the entire order of the sub-collector was quashed and set aside. And it says that and you be, this appeal will be transferred to a mining officer.
Yes,
And let be mining officer, but a deputy director of mines, let him decide.
yes.
Now he has said that I found. This is what
Lordship.
Order.
The money is not.
This is not that, madam.
Item number 7.
Yes, 7.
That's right. Their payer is recovery of.
Yes, yes, Miller.
Recovery.
Madam, he is raising a dispute that as per the agreement, 3% is to be deducted, but his allegation is 5% is deducted actually.
Correct.
We'll file an affidavit to that effect. We are disputing that.
This way clause provides for 3%. How can your authority is empowers only?
You.
Actually, Millard,
Have you deducted 5%? Is an admitted position?
no,
Tell
Millard.
us.
No, Millard. His allegation is that, Millard, 6 lakhs something is deducted. 6 lakhs, he alleges that,
Which is equivalent to 5%?
but our preliminary instruction is that, Millard, actually 5 lakhs 37,000 is deducted.
Is equivalent to 3% or 5%?
It is more than,
Can you,
Millard, ask for
if the clause talks about 3%, then can you deduct more than that?
Millard, I have taken some instruction, but kindly have a transfer. I have marked that question. I have opened this instruction this morning only. Sorry, Millard, one.
He's coming under the EMB class or C&D class?
He is coming under A and B.
EMB or C&D?
A class contract. A class. The A class contractor, let's see, kindly have plans to place 4 paragraph 4 of the repetition.
Let's see the clause, Miller. The class is not required because of the class of classification and deduction cannot be recovery on the basis of class.
They have said that under the OPWD code.
Miller, it is a contractual, Miller, your lordship, it is a contractual agreement between the parties, Miller. Page 73.
If the general rules are imbibed within itself, then all the terms and conditions are also incorporated.
No, Miller, there is no specific. Your lordship kindly has 39.4. Your lordship has the relevant clause. Page 73 and in page 73. Clause 39.4. Your lordship. Your lordship 39.4. In addition to that, I have already submitted EMD, additional performance security. In addition to that, 3% will be deducted from the B. Your lordship.
Restricted it to 3%. How can you go beyond 3%?
My lord, that's my humble
Take heed of this amendment.
But so far that this is the DTCL is the provisions of OPWD code is applicable to that.
Where?
Millard,
By virtue of which clause?
Millard, they have not given the entire copy of the DTCL. Millard.
No, incorrect. I have all annexed your decision. Both parties signed in bottom. Your lordship, kindly see both parties, the present petitioner and the deducting authority signed is this agreement between the parties already.
Is there any clause in this petition specifying that in the event of any amendment carried out in OPWD code subsequently, that will ipso facto apply as impact over this decision automatically? Is there any clause like that? Since you have not enclosed the entire,
I have enclosed entire, my lord. I have enclosed, my lord. Which part my learned friend says is not enclosed, they'll file, my lord.
that is what Mr. Tripathi is.
What date this, my lord, the circular came into force, my lord? Whether this is circular is part of this agreement or not, my lord. That circular which my learned friend is referring is not referred to this part of this agreement. And what is the date of circular, my lord? That is also, my lord.
Is 46 minute, para 3.1.11.
Page 46.
46. What's up?
Yes,
Para 3.1.11.
yes.
Yes. While evaluating tender, that is relating to tender, here the post contract that recovery. Lots of this.
That
While
will have-
your lordship may permit a place your so that while evaluating the tenders, provision made PWD code and government circular issued from time to time will be strictly followed. my lord. Here the post contract they are agreed for 3%, now recovering 5%.
If this OPWD code was already in existence, you are referring 2005 amendment. So 2023, the agreement was entered in. And if you have incorporated a special clause, then what will happen?
They have made it, they have adjusted.
How can you go beyond that? OPWD code is a statutory document or is an executive instruction? If it is an executive instruction, then will it supersede the specific clause of the agreement?
But actually, there is also another point, Miller, which I want to finally give it to them.
What?
Because they have entered into agreement after that cut-off date, Miller. That is there in the.
Sir, but you have allowed them to work. The contention is that they have worked. And if they have worked, you have really deducted the security amount of equivalent to the work they have done. So why you have permitted him to work? Cancelled it. We will not enter into an agreement because it is after the period. Can you now fall back and take advantage of this? Tell me. Will not the concept of estoppel operate against you? Estoppel by conduct or estoppel by representation in both the cases? Why not? If there was a time limit within which the agreement has to be signed, if your contention is that they entered into an agreement after that particular time period, then why you permitted, why you entered into an agreement? Why you did not cancel that particular bid, that you have not come within the time, and you allowed him to work? He has actually worked. It's not that he has not worked. Can you take this plea now? You are a signatory to our agreement.
Well,
So,
well, now the question remains, Miller. What was the recital of that agreement, Miller? That is to be seen.
what recital? Recital is that the work contract has been awarded to him, he has to do the work.
Well,
And the terms and conditions says that if he has done a work of a particular value, then he'll have to give certain security deposit, say 3% or a 5%, that will be deducted and kept as a security deposit by you. So you permitted him to work, and whenever they are submitting a bill, there is no dispute on the quantification of the work. You have deducted more than 3%. That means you have impliedly accepted the worth value for which the invoice is raised, done by them. satisfactorily, successfully.
So far, this 5% is deducted, Miller. Now I'm putting a question to myself, Miller. If there is something in the agreement for deduction of that 5% that is more than.
But then the agreement talks about 3%, very specific. He has referred to this clause 39. He has referred that and says it is only 3% of the total value. You deduct 3% as a security deposit, he has no grievance. But how can you deduct above 3%?
I need to find an affidavit.
What affidavit? This is an open and shut case. You have entered into an agreement with the open eyes, sir. You know what are the terms and conditions of the agreement. One of the terms and conditions says that the security amount would be equivalent to 3% of the work which they have done, or the amount of work they have done. So you can keep it. Maybe for future purposes, that if some default or something, then you can compensate yourself. But can you go beyond that? That is contrary to the terms and conditions of our agreement.
But agreement they have not filed.
This is what the agreement is signed by all, sir, which is appearing in Annexure 2. What is this?
Now, this is a DTCL.
No, this is, we are referring this particular, we are portion of the agreement dated 4/2/2022 is referring this agreement. And this appears to have been signed by a power attorney holder of his company, the executive engineer of a particular division, signed by you.
And this page, the receipt is referring to page 73, Miller.
Yes.
It's not the agreement.
73.
That's why only I pray, Miller.
What is this page 73? This is a part of an agreement dated 4/2/2022.
This is the DTCL.
Sir, if you come to page 11, sir, it is a continuation of page 11. Come to page 11.
Man.
What it says, P1-agreement. What does it mean? And name of the work, you have said that the execution of this is blah, blah, blah. The agreement values is, you have said that this much investment you have given. Stipulated date of completion you have given. Extension of time granted up to this you have given. And then you have signed. On each page you have signed.
That will be clarified, Miller.
What clarified?
One,
Then we will grant a hefty the interest for that. Sir, this is not expected. This is not expected from the state council.
it is fast.
No, sir. You have to be very fair and transparent before the court.
It's the information I received this morning.
What is this? Authorities, and this invites a litigation unnecessarily.
Only one application, Miller, so that it can be clarified.
What clarified?
If they are entitled for 3%, okay, Miller. That will be, we will not stand on the way.
We will say that it is a 3%.
Yes, Miller.
You are entitled to 3% as per this clause.
Can you have a
And very interesting argument. I do not know whether it is an agreement or not. It is an agreement signed by both the parties,
But the place
containing the terms and conditions of the entire work. What more?
There is a confusion between my instruction and this document that need to be clarified. Let it come there to tomorrow, Miller. On the first time, it is
Mr. Tripathi, then you are inviting me to make certain observations. You were served with a copy of the writ petition. And this annexure is a part of the writ petition. You knew that what document they are relying upon. Can you say now that I have to ascertain whether it is an agreement or not? What are you talking about?
So far, that instruction is
No, sir.
That's why I am saying.
What?
Instruction paragraph 4 million.
Sir, what is your role as an advocate? You are simply the mouthpiece of the litigant. Will you not ask him that when you are talking about this, can you justify your stand? Because you have to justify their stand in the court.
That's why, Miller.
First thing is that you have to clear your before you come to the court and argues the matter. If your conscience does not permit this is correct, then what you will argue before the court?
I completely part of that. Sometimes it's conflict with conscience and document. That's why
Nothing.
bring that file an affidavit.
And this is a part of the invitation bid. This is a part of the invitation bid, which he is referring. It's a part of the DTCN.
Let's see, can happen one. That is.
It's signed by both.
I probably, I mean, it's wrong, you know. The first part, let's see, page 11, let's see, pages, that is the T1 agreement. Now this.
No, I had an occasion to peruse it. I stand corrected. The DTCN starts from page 40. Come to page 40. 40.
That's why I'm saying.
Now, when it is a DTCN, there's an invitation for bid, and then it contains 186 page. Correct? He is referring particular page,
Page 70.
which is page 73.
That is part of it.
If the terms and conditions are incorporated in the DTCN, will you not follow that?
We have to.
3% is the very clear, in a very clear terms, 3% has been given.
Forming part of agreement also because they're signed by
Correct.
both.
I see.
That both have signed.
No, that is
Had it been simplicity or DTCN, it would not have been signed by both.
both of it.
So that is incorporated in agreement. At the foot of each document,
Yes, ma'am.
both have signed.
But so far they are saying that it is something beyond that, you know, any there in the agreement. That may be brought to the.
No,
It
yes,
is there in clause 39.4, very clear. In addition to the same, that 3% of the gross value will be deducted from bills of a contractor towards the security deposit, which shall be refunded after the defect liability period subject to the payment of the final bill. So you can definitely deduct 3% of the gross value. Can you deduct more than 3% of the gross value? Here, their contention is that you are deducting more than 3%.
Now, my humble submission is that so far this clause number 39.4 is concerned, as it is a bilateral document, we have to be abided by this one. Let my learned friend make a statement that there is nothing contrary to that in the agreement.
No, this is what he says, more than 5. We will rely on this and will say you can deduct up to 3% or a 3%, but not beyond.
that is my refund application 10th July 2000. You email to your office the proof of communication also next.
Another part, the work is continuing.
True. That is why he says, kindly visualize. The clause 39.4 is created so that the default liability period, which is there after execution of the work, that you have kept it because you have said it is refundable amount.
Yes.
But when after the default period is over, so it is only just to recompensate that if there is any default or a defect which is found in the work. No issues on that. You are within your rights. That you can do it. But can you go beyond 3% is the issue. So they have said anything which you have done. That shows the law on the point whether they can vary any terms and condition of the DTC and after the agreement is over.
The agreement, my lord, here is clearly expressed terms, your
Well,
lordship.
you can't come and argue in a half-baked manner.
No, my lord.
You have to come with the relevant portion of law, proposition of law,
I'll
that they
say
cannot.
they cannot recover beyond, my lord. My
So
I'll cite judgment, my lord. So, your lordship,
that
please
judgment
leave
means that judgment. It is only the bench who will come and find out and then will deliver a judgment.
lordship, once the agreement is page 14 state on behalf of the governor and both parties is a state contract, and now state can say it is not my contract, my lord. So it
Sir,
is,
he's
my lord,
talking about the code. What do you have to say about the code?
court, your lordship.
Whether he is talking about the OPWD code.
My lord, the OPWD code, your lordships, that 3.11 says that, my lord, that it will be by learned senior so that learned friends so that it will be at the time of evaluation. My lord, even if the applicable will have, because his party
Sir,
consciously,
you are interpreting one of the terms of I am talking about the OPWD code, which says that it can be enhanced to 7%.
my lord,
So,
my humble submission,
what is this?
can the OPWD code cannot supersede the contractual agreement, my lord.
Show us the law. That's the law. That's why we say that you have come with a half-baked, you are arguing in a half-baked manner.
Yes,
Will you not look at the law?
yes, definitely. Well, tomorrow I'll cite the judgment, my lord. Once the parties agreed, he cannot, my lord, back out from his promise, my lord, and the particularly state. And the right flows his power authority under clause 39.4, my lord. And the 39.4 authorized to only up to, my lord, the 3%, my lord. I'm only paying you can recover 3%, not 5% beyond the agreed conditions, my lord.
Sir Naik,
Your lordship.
couldn't you follow what my lord?
My lord, I'll cite that to your lordship story, my lord. I'll because
Still you are arguing without following what falls from.
my lord, I'm sorry, my lord. I will cite the judgment, my lord. This is, my lord, whether the present, my lord, I'm not sure.
Understanding more statement that OPWD code is only executive instruction, it has no statutory sanctity.
But
Overriding the, it has overriding effect on the agreement, being an executive instructions. Would you stand by that? Will record statement.
no, but I have to
Please impress.
No, you have said it is the executive instruction. You are going for it.
by 2005 amendment it was inserted.
Mr. At the inception, we have asked you to see whether OPWD code is executive instructions or it has a statutory force and it will have overriding effect on the agreements or covenants
it will have its overriding effect.
Override. Executive instruction.
So far, this executive instruction part is unfamiliar. I have to make some further research. Now let's see, may I draw your lordship's attention to page 27. If there is a possible field, that value 27, there is a mechanism.
Page 27.
Let's come to page 27, clause 27.
Clause
27.
Mr. Patil, with deepest of respect and the humility. Don't say, I'll do something which a lawyer of your stature is supposed not to. First, apply your mind and then make any submissions to the court. You are referring clause 27, what does it say? It says that any litigation that arises will not be instituted beyond the state of Orissa. And you are referring a mechanism. No, it's an embargo which is created, then no suit, nothing of that would lie beyond the state of Orissa. Has he gone beyond the state of Orissa?
Not. I committed mistake. Because 2 pages of not. I'm fine. We grant us one occasion so that we clarify that position.
Homework. You have not done any homework.
I just know the
Yes,
facts. of it.
senior is sitting in, official. Not done any.
I have gone through the
To put for ceremony. Legal aspects.
I've gone through the facts only, so I've gone through the facts, my lord. But my senior had instructed me to dispute it.
What to do?
Let's keep it in fresh admission also.
Next is. And it's like PL of the place contains the letter head vacancies 2025 issue as OP2 is under challenge LRC, where the authority has allowed the previous agreement LRC, previous boat builders to continue for the year 2025 and 26 LRC. The fact remains LRC, the present petition is the boat builder LRC. He was intending to participate in the 25 and 26 empanelment selection process LRC. In the annexure 2 LRC, the government of Orissa, the OP2 LRC, the Department of Fisheries LRC, Director of Fisheries, they have floated a scheme LRC that is called the State Sector Umbrella Scheme, that MMKY sub-scheme financial assistance for the new boat, engine and net for the financial 25-26 LRC. And every year the government empanel the boat builders, and accordingly they have built the boats, and the government supply to the beneficiaries LRC. And in the annexure 4 LRC, for the year 2024 LRC, there was a tender, and according to the tender LRC, the boat builders have been empaneled for the 1 year LRC, 2024 and 25 LRC. And this year LRC, I intend to participate if the tender process will be started in this year LRC. But the authority, without floating any tender LRC, the annexure 3.28 LRC kind of glance, with reference to the letter on the subject stated above, I am directed to inform you that the boat builders empaneled for supply for different fishing boats in Orissa during this year 2024-25 shall be continued till 31st March 2026 for smooth implementation of the government schemes, and the term mentioned in this office reference letter shall be remained unaltered. My challenge to this LRC, the guidelines under annexure 2 LRC, that is for the year 2025 and 26. And in the guidelines LRC, there is a clause in page 18 LRC, kind of glance, clause X. The boats shall be procured from the empaneled boat builders selected by the Director of the Fisheries through the tender or LRC. Violating the guidelines under annexure 2 LRC, the authorities issued the direction under annexure 3 LRC to continue the previous year's empaneled boat builders LRC, by which I am affecting LRC. I have intended to participate in this year tender process LRC. That is the grievance.
Is there any restrictions that only the impaneled boat manufacturer or boat builder?
Yes.
Can only participate in the tender?
No, my love.
So guideline does not really restrict only the impaneled boat builder. It is an open one. Whoever is otherwise expertise in building the boat.
Yes, LRC. I am one of them LRC. I have not been impaneled.
The impanelment is continued.
Yes.
But not.
I am not been impaneled in the previous year LRC.
Make an application for impanelment.
There is no scope to me LRC.
Why not?
The government has already continued. This is the challenge LRC.
The impanelment which is there will continue till
Yes.
March 2026.
My lord.
That means that they are carried forward. Their extension is given. That does
Yes,
not
Lord.
mean that they cannot include anybody.
there is no, in the 2024 LRC, they have floated a tender notice LRC. And in view of the tender notice LRC, the boat builders, they have applied and a bid was open and accordingly.
I'm again asking you, I asked you a very specific question.
My lord.
first. This guideline talks about the floating of the tender and procurement of the boats.
Mine.
Whether this tender restricts only the participation by the registered or impaneled or it is an open tender. Where
It is an open tender LRC.
So why you can also participate. There is
No tender has been floated
It is
LRC.
up to them whether to float the tender or not to float the tender. Have they procured anything? They have simply carried forward the duration of the impanelment.
Yes.
That's all.
My lord.
That does not mean that they have also extended the work. That is not common.
Yes, LRC. That is the language LRC.
What is the language?
Yes, sir, Lord.
Impanelment will be continued till 31st March.
Yes.
That's all.
And they will work.
That is the stipulation.
With reference to the letter on the subject header above, I am directed to inform that the boat builders employed for the supply of the different categories of the fishing boats during the year 24-25 shall be continued till 31st March 2026
Correct.
for smooth implementation of the government schemes, and the terms mentioned in this office reference letter shall be remained unaltered.
Unaltered.
In this regard, you are instructed to select beneficiaries for availing of the boats during financial year 25-26 as per the guidelines under various state schemes, structures, and PMFSY schemes, and issue go ahead to the selected beneficiaries for construction of his
Now the
boats.
question is, if there is a scheme which says that say impaneled boat builders will be allotted the work.
Yes.
That is what is. Have they allotted any work?
That information not with me, LRC.
Then how can you maintain a repetition on mere assumptions?
Must take the language of the instructional LRC on Annex 3.
Maybe, but at the time of the guidelines, if they want to implement, if they float a tender, then
After the guidelines LRC on Annex 2 LRC, the guidelines
you could not get it.
is
You could not get it. If you come and say that any work is allotted or entrusted upon the impaneled boat builders only and not by open tender. Even you can come and challenge that this is now the work order and this is how they wanted to do it. But here nothing has come forward as of.
Annex 3 LRC, they have already clarified that they will work LRC.
We are not impaneling any other boat builders now.
The Annex 3
the policy.
LRC, that means LRC, they will work till 31st/3/2026. That means LRC for this coming year, financial year 25-26,
There are
they will not.
there are in a government administration, there are many small fringe things are already there, which can be procured without. The tender has certain values. Then beyond this value, certain works can be executed through those impaneled builders. Repair of the existing boats. Some screws are torn off, rusted. Those are required to be replaced. A refurbishment is required to be done. Does it require a passive tender if one boat is only there, which does not take more than 40,000 rupees or 15,000 rupees for? Why? Otherwise, the government cannot run the administration.
That instruction will be direct LRC kind
You
of.
are not saying any work is executed.
That is not
of a high value, I can understand. If it is of a high value, no doubt, no doubt.
The impalement on Annex 4 LRC, it was made for construction of a new building of new boats LRC.
The boat being of a very small value. Please consider that. It's not a building of a ship. which would cost millions and millions of dollars. Wow.
The scheme ownership, very clear ownership, the tender was for the clear ownership.
Shoot the guidelines.
Minus
What is the issue?
OP2 ownership, director of the fisheries.
Any issue of guidelines?
And annexed to a page 15 ownership, the
And who has issued that particular extension order?
also OP2 ownership, the director ownership.
So
National Director of Fisheries.
both.
Yes. The guideline issued by the director and the additional director of fisheries issued the letter.
What is your response?
Take one stop in the response.
What is the instruction you want? What is the instruction that we want to see?
And in this, so far this annexure P is concerned with that is, let's see, we'll find that is issued.
Wanted some instruction. To be received by you. What is that?
My instruction will be that whether
What sort of instructions you want to receive, sir?
and whether they have assigned the work or not. And so far this annexure P is concerned with that is in consonance with annexure 4.
It is of the military model.
Item number 9.
Petition is by the Sarpanch and Panchayat Samiti members of the Bhapur block to the selection board for beneficiaries of Antarja Gruha Yojana in Bhapur block. my lord, the guidelines we see that annexure 1, it provides the modalities with regard to selection of beneficiaries. And your lordship will kindly come to page 21, clause 4.2, more particularly 4.2.1.
Antyodaya Griha Yojana.
Ma'am.
What for?
This is for the poor strata people who do not have Poka building
House.
and Poka house, and those who have income less than 15,000. These are all criteria. And your lordship will see page 21, the exclusion criteria is fixed in 4.2. And one of the first exclusion criteria is that if somebody has a
Staying in a Poka house, then he does not come.
much obliged, your lordship. Now your lordship will see annexure to page 37, the CDO come executive officer Jilla Parishad writes to all the PDOs of Noida district that 15 numbers of eligible households
Correct.
or GP should be selected.
Correct.
Now your lordship, in portions of that, your lordship sees annexure 3, page 38. 20 persons are selected as members to conduct inquiry and submit 15 numbers of eligible households from each GP.
Right.
Now, what they have done, your lordship will see the proposed list that went is 225 in number. Your lordship will find from the last page of that list, that is page 49, it is 225.
Yes.
Now, in this list, at least 5-7 panchayat has no difference at all. Absolutely. Then out of these 10, 8 gram panchayats have no representation, though your lordship has seen 15 from each gram panchayat. Now, apart from that, from these 225, the scrutiny committee, your lordship will see annexure 5 is 50. They select only 84. And there are 5 may say why they have excluded others, but they selected 84. In 84, that finds place, your lordship, at page 52. It commences from ends in page 53. There are at least 24 individuals who are having Poka house, which is an exclusion category.
Have
We
you proved it by any evidence?
My lord, we have given a list to the collector saying that an inquiry should be conducted.
With any kind of, the documents simply saying orally. Even
No, we have done this, my lord. Let me just point out. First of all, your lordship has seen the process. 225,
No,
only
I
84.
understand,
Right.
sir. This is not, but I am asking you, when you are raising an issue, there must be some corroborative document.
My lord, in fact, we have.
Beating the bush will not do.
So true it is, my lord. What we have done, we have represented to the collector twice, saying we have furnished the list. Your lordship may kindly see the list at page 70. Page 70. I think page 70. The list of ineligible persons. Page 72. Page 72, your lordship. I have given the name, the registration number, because they are all registered also. And I have said Chhatagara, that's the Poka house. They are. These persons have been specifically named, and these persons' name finds place in the 84, and their serial number also.
From where you got this notion that they have a Chhatagara? There should be some corroborative evidence.
May I just
that the record of right which is standing in their name shows it is a Chhatagara. Some presumptive values, some documents.
Now here they are all public representatives.
That shows there is another equation that comes. You are the person who put a spanner to the implementation of that particular.
My brother, your lordship will see the allegations. I'll just point out one.
Mere allegation. Everybody comes with their allegation.
They are all public representatives. Your lordship has seen. They are not persons. Someone has come, an individual has come. They are sarpanches and the representative of the people. Now, what has happened?
Representative of the people, since they are coming up.
No, they have also special means of knowledge with regard to the persons of their panchayats.
What is there? So will they not? There must be a panchayat document. They are the custodian of the document. What is that? They must be holding a document with them.
Now, so far as the RORs and other things are concerned, they will not be holding it, but they can very well get it from the bullet.
In the panchayat area, don't you know that what is happening there?
That is what has been pointed out, your lordship.
Only oral.
A list has been furnished
Correct, so
with
why?
specifications.
Why? Why? There must be a corroborative document.
That document has not been
Then,
furnished.
then how?
But you will see what has happened, my lord. Here,
Properly, they wanted, they closed, went there and filed a representation. No corroborative document. Now, we have 84. So, their position would be altered. They will not be able to proceed on that basis because the representation they have to consider and submit a report.
one thing, may I just point out one more thing, my lord? Piece of document I'll show to your lordship is serial number 12 beneficiary. He is a PWD contractor in your lordship, may kindly see. He is a person should have income of less than 15,000. He is having a GST registration and a page 113, your lordship, may kindly see. This 24 includes this petition, this gentleman, the Govinda Chandra Swine, Annex 9, page 113. He has a registration certificate, GST registration certificate, and also a PWD contractor's license, page 113 and page 114.
Yeah.
And his name finds place at serial number 12 of the 84 beneficiary list. So therefore, he is one of the person who should have been at least a documented material is there to be excluded. Apart from the other persons, 23 persons, which your lordship has been pleased to point out.
Threshold for taking out registration number. This was
The GST is there.
for works contractors.
Works
There was nil. In GST,
In GST plot, it was 20,
20,000.
20 and 40 for services.
20,000 per year.
20 lakhs.
20 lakhs.
Yes.
That is what.
40 lakhs
No,
for
for
services.
works contractors.
No, for individuals.
Individual. For works contractors,
Works
is there any specific?
There's no specific bar, but without a GST registration,
But
TDS
under that, as well as crypto turnover or contract, they were bound to.
bound to have a registration.
one registration.
Otherwise, the TDS cannot be effective.
No, under GST, I was just verifying.
It's 20 for good, 20 for goods, 40 lakhs for services.
Mr. Tripathi, this document is also corroborating the other matter where you have taken a plea. Here also says 3% as security. Do not talk about more than 3%.
These construction contract.
You were talking about 5%, that if I am saying that here also 3% is used. In the memorandum also. And page 150.
Column number 8.
Percentage to be deducted. F. Security deposit. 3%. It's not more than that. Let's check out.
Must be contractual seat.
That is what I'm saying.
You check up.
Yeah. Oh, definitely, yes, what is your stand?
My lord,
What is your document?
My lord,
At least one evidence has come.
Yes, ma'am. My lord, my lord, may kindly come to page 51, which my lord, the list of 84 persons staff. My lord, at page 52, my lord, at serial number 12, contractor's name is there. Govinda Charana Swine, my lord may say the last column, my lord. The remarks column.
Serial number?
12, my lord, at page 52, serial number 12. Lord Govinda Charana Swine, that is the person.
Correct.
My lord, the last. Govinda Charana Swine, my lord.
Yes, yes.
My lord, the last.
What is written?
My lord, it is written
Main-
PWD main earning member. My lord.
Person with disability.
Disability. Now, my lords may kindly come to the guidelines at page 21. PWD main earning member. Now, my lords may kindly come to page 21, which is the guideline. My lord, the 4.1 is the eligibility criteria. It starts, my lord, the houseless or households living in kacha houses will become eligible for sanction of new house if they come under any of the following categories. And at clause B, it is mentioned households in which the main earning member is a PWD with minimum 40% disability. My lord, I have received instructions, my lord, may kindly see. He's a house and he's a person PWD who's the main earning member and a PWD. So under that category, he has been given the benefit.
Your Lordship may see the exclusion criteria, page 22, 4.2.6. Households with any member of the family earning more than 15,000 per month. So he is a contractor.
But if he comes under the special category where there is no barrier, then it's different what to do.
There is a exclusion criteria.
But there is a eligibility criteria.
True it is, madam. So both has to be read together.
So
So, madam, my humble submission would be a PWD person having earning more than 15,000 today. That much, that has to be read harmoniously together, both the clauses. It is not to exclusion of each other.
We go with taxation principles.
But they have placed a
That eligibility criteria has to be strictly construed, but when it comes to exemption criteria, it has to be liberally construed.
So it is, madam,
So
but
both has to be harmonized this way. As far as I know the concept of
I respect,
understanding the exemption notifications.
I actually,
How the Supreme Court laid down the with
My-
regard to eligibility criteria, so far as exemption notifications are.
the only thing that I beg to humbly submit, my reading of both, madam, would be that a PW person having more than 15,000 income has to be excluded.
because we find that that will show, because when there is a eligibility criteria, and when there is an exclusion criteria. then one may come under the eligibility, will fulfill those, but if he is otherwise excluded, then in that event, the exclusion clause has to be given a primacy. That cannot be ignored.
Yes.
His primary eligibility criteria is the person with disability. So he really counts. But if his income is more than 15,000 rupees, then what would happen? So the question is, he has given that he is a registered contractor.
Yes, ma'am.
That does not mean that a registered contractor is entitled to a contract. He may not get a contract, though he is a registered contractor. This is what criteria one has to look at it. Because his claim is under that he earns 15,000 rupees more. I mean, 15,000 rupees a year. He has not produced any evidence that he has earned 15,000 rupees or his earning is more than 50,000. So we'll have to just satisfy the income criteria as well. Secondly, if one example has come, then what about the others?
Other persons, my lord, they say, my lord, that list that they have prepared of 24 persons, they say all the other persons, they say that they have Chhatta Gharas. But my lords will kindly find from the guideline that Chhatta Ghara is not the only criterion. My lords may kindly come back.
Meaning of the word Chhatta Ghara.
Chhatta Ghara,
I do
my
not
lord.
know this particular.
Pakka house. Chhatta means it's a pakka house.
No, it does not mean a pakka house. It means a
Now difference.
I'll just, my lord, Honorable Justice Raman can appreciate. Exactly. Kacha house cannot have a roof. It will have a this.
What are you doing? They will not have a roof.
No, it can have asbestos and other things. It cannot have a roof. Or
Still not.
Noda Ghara.
That's the common word which is used there is a tali ghar.
Yes, tile ghara. Tile. Say that that's a different thing, Your Lordship, because that's not a pakka chhatta. Pakka chhatta means it's a roof. That's a concrete roof.
Chhatta ghar does not mean that. Chhatta ghar, I do not know.
Word pakka is not prefixed. Here, you are adding.
No, that is the thing.
If I do a revision of the word, chhatta commonly known as an umbrella.
That is chhatta. That is chhatta.
But in other language, it is called as an umbrella.
In fact, in the guideline, pakka has been defined.
Yes.
Your Lordship knows my Chhatta Ghara can be a Kacha house. Because Kacha and Chhatta, pakka has been defined in page 19 of that guideline also. It can never be.
No, that is, I understand. So far as, but Chhatta Ghara, this expression is very.
It may not be expressly mentioned pakka ghar.
It's not very much known to me.
Chhatta.
Wall and roof.
Exactly.
Both wall
Chhatta Ghara mane. Chhatta Ghara kacha ta hai paribani. Kacha Ghara will not be able to withstand anything. Fine. 1.2. Pakka ghara is which can withstand. So that is the distinction.
Distinction is one which can withstand the natural calamities. And one which cannot withstand the natural calamities. Both can withstand the natural calamity.
Roof is also defined.
And in fact, Your Lordship, 8 Gram Panchayats have been totally excluded. They have to say why that is absolutely not a single person eligible from those Gram Panchayats. 8 Gram Panchayats totally excluded. And that is not the case here. But if
there may be certain villages
and
Gram Panchayat, there the very affluent locals are living. Who knows?
And here
I can give you, don't say, I'm not saying this.
No, there are panchayats.
I can give you at least 4 villages, village name. There, the residents of the village are a rich person.
In fact, I came across one panchayat near Bhaijak that is absolutely like a town, but it's a panchayat.
No, it's not panchayat. I'm giving you.
Right.
The rich man.
But here Lordship is also 84, they truncated to 20.
Some villages in Gujarat.
My. Here, my lord, 225 comes down to 84.
Don't say that it is always.
No, not. It has to be based on facts, man.
You have to embrace it and you should be proud of it. At least the gram, 8 grams are not coming under that poverty level. They are rich.
That it is stated that they have been excluded. Illegal.
Not excluded because they are very rich. They do not come.
My lord, yeah, that paragraph 12, page 11 of the petition.
Whatever.
We have stated that.
To counter this.
My lord, sir.
And I do not know the meaning of this word chhatagram.
No.
He says paka, you says no, not
Well,
paka.
When they
I
say
do not know. This is
Chhatagaram,
what a dissent comes.
well, their grievances, they have Chhatagaram. So let them explain what is meant by Chhatagaram. My
He's saying
understanding.
paka. He's saying paka.
My lord, Pakka and Kacha has been defined, my lord.
Correct. So he says chhatagram means a paka, RCC slab.
No, my lords. My lord, may kindly come back to the definition. My lords, may kindly come back.
Please, you can take paka.
My lord, Pakka says both the wall and roof are Pakka. Both the wall.
Paka means what?
Pakka means
Made up of
RCC.
what?
Cement, my lord, cement, RCC.
This is what I'm saying. RCC roof.
RCC that is defined also.
RCC roof.
Yes,
Made of RCC material.
Yes.
That is 1.1.3.
My lord. So if my lord may then permit me to file an affidavit.
What means that? I do not know.
So my lord may permit me, my lord, to file an affidavit as to what are the houses of those 24 persons.
This is what we might.
Well, very much so.
So you still require.
No, my lord. But my lord, and it has been.
Colloquial
No, my lord, that is a
meaning
fact.
of chhatagram.
My lord, any house, as per the definition, my lord, any house, only, my lord, whether it is be the roof or the house or the walls, if any of them is kacha, then my lord, it has to be considered as a kacha house. But whatever it is, my lord, these are factual things. My lord will permit me to file an affidavit, my lord. If they're making of those 24 persons, what is the house, my lord? What house? My-
We will not forestall, sir. Not at all, at your instance.
It's 24-year-old.
No, sir. File it within 2 weeks.
my lord.
Beneficiary scheme must continue.
No, that I will never stand in the way. And my
You
only
have,
grievance is on the,
you stood in the way.
where the 24 goes till 60 remains.
What is it?
We are not standing on the way.
Item 10.
Man, I only pray my heart 2 weeks ago. Time is direct for it.
Here.
Okay.
Let me look. Tender. Let me pronounce. Pursuant to a tender law for 2 patches of work. Pursuant to a tender law for improvement of 2 patches of roads in the district of Ganjam, the petitioner being an eligible contractor, he applied law for approval. He submitted his EMD, which was accepted by the system, and it was also credited to the government. But when the portal was opened, this particular transaction was shown to be pending because of some technical glitch. And unfortunately, the petitioner could not proceed further to submit his bids, the technical bids.
It's still pending.
So it's still pending. I have also filed an affidavit for your lordships. The financial bid has not been opened till the lordship and the lordship would appreciate. I've also got a confirmation of the bank because they wrote to the bank that this is the glitch which is shown. The bank said went out on the said date. The amount has been transferred to the government account. I've also filed that affidavit annexing the bank's letter. I've also filed an affidavit law and letter. The lordship will take up. This is the affidavit which I have filed stating that the financial bid has not been yet opened, even though the technical bid has been opened. And if the lordship would see the other document, the bank writes a letter. I've annexed the letter of the ICICI Bank, my lord, if the lordship will see. They cover both the two writ petitions, my lord. So they have annexed the documents which should go to show, if the lordship would see, that on my complaint, the second page, if the lordship would see, second page is a query, my lord. For confirmation of payment status, if the lordship would read, dear team, lordship got it. Request for to confirm the payment status of below e-collection details. Then the government account is given, my lord. Then the name of the petitioner is given, my lord. And the date, my lord, on which this is supposed to was paid, my lord, was also given. One is 5/7, that's the second writ petition. And the first writ petition was 7/7. Then if the lordship would just come back to the first page, I mean the second page, here your lordship would see, my lord, please find attached screenshot post verification status is showing
Status.
pending. Status.
Status.
The spelling, my lord. I'm sorry, because that is status is showing pending, laws, because of this word pending which was shown, Lord, I could not upload my documents. Then, my lord, today is the 5 p.m. cutoff date. Bank also mentions that please furnish the details because 5 p.m. is the cutoff date, Lord. Then, my lords, Mr. Ganesh, he says, he addresses that letter, my lord, that we have received e-collection against mentioned transaction. And this is, one was mentioned, my lord, was received on 7/7. The other one was also received on 7/7. So it has gone, my lord, and the second column, my lord, the file name is the government account, my lord, in both the cases. And unfortunately, if your lordship would kindly turn to my lord's. On that page 64 of my writ petition is a part of annexure 2.
What you say,
Let actually
if
direct.
the portable, if the technical, if money is received, but the others are not received, then it shows the pending.
It shows pending, Lord.
It never says, though it is debited, but shows pending. How can they? Because the portal will not open unless it is deposited.
And an only limited instruction I have received in this matter. Actually, there were five bidders in part number 1 and 4 bidders in part number 4. Part number 2 bidders. All these bidders, they have successfully uploaded their
When
on the same day.
same day, if they clear, then why his status was shown as pending? It may be at what time? Well, have you checked the time of
Yes.
their upload?
Yes.
Uploading of the document, what is the time?
In respect to work number 1 bidder, it is between 10:58 a.m. and 3:54 p.m.
Huh?
on 3:54 p.m.
Hmm.
on 7/7/24/25 and on thereafter 3:54 p.m. On 5/7/25 before that.
That is on that, on 7th of July.
Yes, my lord. On 7th of July, 10:50.
Then why it is showing as pending, the amount has been debited from his account, but it is.
It was not
pending.
uploaded. It was not credited in the account of the government.
What are you talking about?
The bank
The transaction has gone.
Now the document is my lord, is filing now, my lord.
Please show us that the document has gone or not. The money has gone or not. The bank is certifying that the money has gone to the government.
This was on 7th.
On that point.
There is everything is clarified by the bank.
Now I have received it.
What now?
That's the matter.
Clarified. Don't proceed with the
Yes,
financial bill.
I assume my lord, we will.
Don't proceed with the bill.
That should be taken up day after tomorrow.
Day after tomorrow, we can give you take.
Yes,
But if it is a technical glitch, then you'll have to permit them to file a physical or whatever. You include that in a technical bit. He qualifies, he has to compete in the financial month. There's no difficulty. Or otherwise, if you have any question.
no, my lord, let's see, if you're, let's see, day after tomorrow, I will inform the department.
Item 11.
Both the matches, there are two works, and the certificate of the bank covers 20 lakhs, two works for the same tender. The bank, my lord, they say about the amount of money for both.
180. 180. They have not find a counter. How paragraph 1 will go?
Yes, Item 12.
Petition is a government of India undertaking, but the Ministry of Railways.
Your bid is rejected on 8/8/25 at the technical stage.
Yes.
Technical bid stage.
Yes.
Where is that?
That is mirrored at 157. You see the rejection.
Extract of board resolution not attached.
Yes.
What is this?
Mirrored. In fact, along with the appendix 2, which is a power of attorney, it has to be signed by the person who is authorized by the board. This extract was not required to be, it is not a tender condition that it has to be signed. Your document kindly see 81, page 81. Page 81, this appendix 2 is the for signing bid. This document I have given. Kindly see at the below signature, name, designation of the address of person authorized by board resolution. In case of farm and company, I am a company, so therefore a person who he has to sign a board resolution. Then
where do I get it at page 81? I am not getting. Oh yes, signature.
Yes. So signature has to be done by the person who has been authorized by the board, but he is giving the power of attorney, and there below a person identified who have to accept this.
There is no clause saying that
Yeah.
there is no clause requiring you to find any extract or.
No. Rather, kindly see 82. Kindly see 82, page 82. Second bullet. Wherever required, the bidder should submit verification, the extract and counter of document such as board or shareholders resolution, power of attorney in favor of person executing this power for delegation of power hereunder on behalf of bidder.
This is what if you are a company.
Yes.
Then the board of directors.
Yes.
The signing would be done by a person authorized by the board of directors.
Yes.
So the resolution of a board of the board of directors.
Yes.
Has to be appended there.
No, there is no.
There is no.
There is no requirement. Kindly see.
That it says that you say that he is as an authorized person, he can put his signature.
Yes.
And then you say the bullet 2.
Yes.
That for verification, if they want, you can produce that.
Yes. Yes.
This is what you are.
Yes. And kindly see documents at page 47. What documents I have to? 47. 47 2.11.1 B. Power of attorney for signing bid as per format at appendix 2 only. Yes.
These are the requirements.
Yes, the requirement is only appendix 2. So 2 doesn't require the board's resolution. And kindly see 2.1.2. Railways, Miller, I have soft copies on the Deputy Solicitor General. Miller? Yes, I have soft copies on them.
My lord, I have obtained the copy, man. I have the copy.
Yes, you have the copy.
My lord.
You have to say that how can you reject that extract should not have submitted if it is not the condition precedent.
Not required.
Then in that
Tender
case,
it is not-
no, requirement is there for the purpose of verification. They can call it.
Yes.
Okay. So, but that was not a condition precedent for submission of the bid. You are not included in. How can you reject the bid? What is the stage of the?
Millard, that they have opened the financial bid, but
That's why you came late.
no, Millard, the very day, that same day when the technical bid was rejected, that very day they opened the financial bid. Now LOA
Continuously.
simultaneously, one after one. And Millard, LOA has not yet been issued. Letter of acceptance has not yet been issued. And Millard, we are 42 crores less, and I am a public
It's not
sector.
there in the printed document. Tell me.
My lord, since this is a
Mr.
question of
Mr. Counsel, when it does not really talk about anything, that it should accompany these documents, can you reject it? You can ask for verification, they will produce the board resolution, their internal matter. How you are
Correct.
concerned with that?
I
The
do
company
understand.
has not come forward and say, I is this person to sign?
My lord, since this is a question of authorization and it involves disputed questions of
What are you
fact.
talking about?
Instruction, my lord, in this.
Question of authorization? No, it's a question, is a submission of the bid on behalf of the company, corporate entity. And
My
the
lord.
company's law says that either a director or a managing director or any person authorized,
My lord.
he can sign on behalf of the company. And the board resolution is their internal matter.
Your
Correct.
They can
format,
produce.
your format doesn't require a copy of resolution to be enclosed as mandatory condition. Or it is not a sine qua non.
It simply says that a person will sign a document who is authorized.
My lord, that is true, my lord, but I will take instruction in this matter. my lord.
No instruction. You can't proceed and give an
10
order.
days time may be
LOA.
given, my lord. Under which
Yes.
circumstances this has been done, my lord, I will take instruction.
No circumstances. This is absolutely, your document is very clear. Which page? The rejection?
157.
1?
157. 157.
Yes. Extract of board resolution not attached. You can't go beyond that. And where is appendix 2 or annexure 2?
Millard, that is 81.
81. Well, only one time may be given, my lord. Only 7 days time I will take instruction.
No. Then we are
Lots may pass by, my lord.
we are staying.
Stay may be there, my lord. Only 7 days time so that I can take instruction. That can be heard on merit.
And these witnesses were signed. Everything was signed. This witness alone.
LOA has not been issued.
My lord, let that be
Annexure
shared.
2,
The Bhanti.
appendix 2.
Yes.
The witnesses, they signed.
Yes, they signed.
It was duly notarized.
Yes. Notarized. Millard, I have given at page 129, 31, 31.
129.
Yes. This is the power of attorney, which I have submitted to them.
let there be a stay order, and this matter may be taken up 10 days after, so that I will take instruction and can be heard on merit. Let there be a stay order, my lord, I am not disputing.
Yes, the bid submitted by the petitioner is rejected at the
Item 13.
Yes.
Item 13, my lord. The petitioner brings the decision of the tender committee in declaring.
Disqualifying. Where is the order disqualifying?
Madam, qualifying, madam. In declaring the OP numbers
Oh.
qualified despite not having the requisite.
Sorry, you are challenging the eligibility of opposite party number 6, though you are ineligible.
No, I am also listening.
Achha.
I am also.
I just thought you are ineligible.
In this case, OP number 6 is a registered society. In the bylaws and the memorandum of association of the society, it does not have any aims and objectives that is remotely connected with the issue of housekeeping service, the subject matter of the tender. Despite
I think this matter appeared before.
yes, madam. Today, on item number 50 in another district. This is in
I think this matter appeared earlier also. Maybe some other.
Similar, same petitioner also same OP number 6 in item.
What has happened in other matters? What?
Here also the technical bid has been opened and he has been awarded the highest marks in technical bid. I have also been awarded the highest marks.
Then the toss.
Madam, the tender condition.
Then the toss.
No, no. After that, this is that if in the financial bid, if the financial bids will be same, after that they will go to turnover. Whoever has turnover will be declared as well. I have my turnover is less than the OP number 6.
Okay. So they are already working in that field, though their memorandum article of association does not cover that.
No.
Can it show us under the Society Registration Act? Are they registered under the cooperative society as a cooperative society or under the Society Registration Act?
And the registration certificate is that.
Under the Society Registration Act? Correct. Show me one provision of the Society Registration Act which forbids the society to do a particular work which is not contemplated in the articles or the memorandum. If by a resolution, if they really wanted to do it, with all the members and with the majority, then.
That will be subversive of the objectives of the society, man.
Sir, if all the members had decided, who are you? You are an alien to a society. If the members of the society, if they agreed, then can you stand in a way being a
It's the bylaws of the OP number 6.
Sir, show us from the law that the society cannot do a particular thing or act beyond the bylaws or the article of association under the act itself.
There is no express provision in the act.
That is, please show us then if that can be done, then there is a difficulty.
That is clear in the Companies Act is also applicable in the society's case.
Sir, you can't borrow. Sir, under the Companies Act, they are under the constant service. There are many obligations under the Companies Act.
In companies, like they have to file the memorandum of association. Societies Act also requires them to file a memorandum of association as well as on the aims and objectives of the act, which are considered as bylaws. Similar. The moment a society across the company is being registered.
Sir, I am asking you, sir, you can't borrow the concept of a company into a society. Both are distinct and governed by a different act. Under the Companies Act, there has been an embargo. Under the Society Registration Act, show us the embargo.
In the society's registration. Sorry, but I'm carrying the.
So if that is what you are arguing, then you will have to show that this is what the section is. This section prohibits that even if the difficulty is under the Society Registration Act, it is all the members who have to take a conscious decision and the majority would prevail. The affairs of the companies are managed by the board of directors. The entire thing rests upon them. Shareholders in an annual general meeting, and there is also criteria which is given. How far a shareholder can interfere in the affairs of the board of directors. So you can't borrow both the concept into one bracket.
Sorry, I'm not carrying this section 37 that gives the register the power to cancel the registration of the society.
That is up to them. Then who are you to come into this? That is between the registrar and the society. whether you have any legally enforceable right. You have to show that this is what an embargo, this is what an absolute prohibition. They can't do it. I can understand that they will be.
But if they want to carry out any purpose or act that is not in their, not in their
Sir,
bylaws, they have to amend.
Sir,
the
you are repeating the same thing. I am asking, sir, from the any statutory provision, show us. Show us the statutory provision. Don't carry the notion that if a society is registered, it cannot act beyond that particular memorandum. Even if all the members of the society uniformly they accepted and adopted a particular thing to be done.
Next, the provision in the society is admin that.
Then show us the bylaws where they can say that the society can. Every bylaws has the omnibus or a, I say uniform clause.
Nothing clause. However, in this bylaw, in their bylaw, that is at page number 85, starts from 85.
Yes.
Not 6 of the bylaws, aims and objectives.
Forget about it. Just imagine what they can do.
There is a past provision that is healthcare. And this is housekeeping services in the hospitals bylaw. The clauses under the healthcare bylaw, there are no such bylaws that enables them to carry out the housekeeping services or much less a service that includes providing manpower.
What do you say? I do not find I find that there is no bar. There is no bar from their articles of association or the memorandum.
It doesn't have such a bylaw that's enough.
It could be because I have seen that particular clause F of page 89. Last sentence of that.
Do all such other lawful things as may be incidental or conducive to the attainment of the above.
Thereafter.
All both the major and auxiliary objectives will.
So what is the major is there, which you said, and auxiliary is always there. That's the objective incidental. They may vary according to their specific use or need of the organization. So if they have varied it, can you say that they cannot do it? I'm just asking. Very simple question.
I'm not very environment,
What are you? They can. They say that is within their powers.
but they can, but
Both the major, no, what are the major? If you come to the main object, that is a major. Aims and object. That is a major. And then incidental.
objectives incidental to the main objective.
Correct. And then it says auxiliary. That means an incidental. Says objectives will vary according to the specific need of the organization. And then the second line, all the incomes and earnings, they will be utilized. So if they do not have the income, how can they utilize for these plain purposes? So for having an income, they can definitely go there and can ask for.
But they have not done it. But it has consequential difficulties in the sense that they have now undertaken manpower, but they are not providing those employees that they are undertaking under them. They are not providing them ESI and EPF card.
So that they will, ESI department will take care of that. If other departments will take care of. Who are you to? Are you controlling? Are you managing the affairs of the society? Do you have any power to interfere with the affairs of the society? You are a third party. Be there. Be there.
The result of that the FIR has been lost. FIR has been lost by.
So the contract cannot be done. I am making observations that there is no bar in that sense.
There is a clause, my lord. There is a clause in the case under BNS or any criminal law for the timing in force, you have to declare that. And if you have not declared, you're
What FIR has been lodged against them?
FIR has been lodged by employee who are stated that.
When?
FIR is that, my lord. In the month of March.
And when the tender was invited?
Tender was in 17/4, my 17/4 in the month of April.
Of 2025?
2025.
Yes.
FIR has been prior to that, 16 days, 16, 17 days.
Was it intimated to them? Any report, any notice was given? Nobody knows. An FIR is lost, but there was no investigation which is done. The police has not come and intimated. Police has not come for the interrogation. One is not omnipresent. That somebody in Kerala has lost an FIR and somebody who is living in a Cuttack will immediately come to know that a FIR is lost unless the police have and given an intimation. How can a person know that something is happening and that too in a very close proximity of time within 15 days?
Regarding that, I'm taking.
No, sir. Once a successful person, I know what is there. And you do not know the fate of this FIR.
My grievance was before the consideration of the technical meeting.
This is a issue, but he is unable. He is unable to. No, Society Registration Act. But there is no provision. Rather, the provision is that they can alter the purpose.
We cannot. If they
Sorry,
if they want to undertake any work,
sorry,
it's not
nothing.
in the
I am referring section 12 of the Odisha amendment. Odisha amendment is very clear. If they want, they can change the purpose
They
also.
have not altered.
That is, no case is made out by you.
And they have not altered.
No case is made out by you that they have not altered.
Because their work is not within the bylaws of the.
Sorry, we can't. Altered means they can take a resolution. There is no difficulty.
That extent has also.
So you can't gather an evidence through our litigations. Yes. D'accord. An unsuccessful bidder approached this court, taking. Same price, the authority decided on the basis of a turnover. Since their turnover was more, they have been declared as successful. If that being the position, then the financial bid was opened. If my brother and other members who are here, your argument is this.
I will not put it forward the right way.
Get it down. Strike down. It is
Besides this, the rate. Now, I am telling it along with that ground, the other ground, that clause 5.6, your lordship can have it is 35. Case 35, the offending group, and I have quoted it.
5.6. Yes.
The corporation reserves the right not to consider any person or firm, company having any dispute with corporation or whose operation is found to be unsuccessful by the corporation during the previous assignment in order to protect the interest of. So this is they by directly put a restraint from going to any legal proceeding or having any legal proceeding. That's therefore my respect to some reason is section 28 of the Contract Act. So it can have the section 28 and also against section 23 and article 14. And the second part is that they themselves being the
Have you participated in the tender?
Previously I have engaged. This year it has the bid is not ended. The last date has not gone.
Whether this clause was there in the last year bid tender document as
That I
well?
have to check out.
Please check us. First tell me.
And
I will appreciate your point, provided it was not there in the last year tender document, where you were successful one.
no, the tendering process is going on. It has not.
When you were declared as successful tenderer, in that tender document or a bid document or a tender document, this clause was not there.
Exactly, I have asked him.
Please show us. If had it been a case not there, no difficulty. If it was, then some queries may come in your way.
But, I have asked him to give me the last year document. So unfortunately, it was not with him.
You show us. That is very important.
And I checked in that it was there in the last year.
If it was there,
It was there.
tell us that
It was there.
whether you can challenge it on such ground. Just to forestall the things, because we will not extend your time.
No, I'm not
We
seeking
will
any
not,
extension.
don't extend his tenure.
No, I'm not.
If it ends, it ends.
It ends. It's ends. I'm not seeking for extension, but my case is this, my lord. This is a directly.
His tenure is when it is going.
I have
to
already. It has already expired, and
so you are not extended.
Like what happens till the new man comes in, they continue an extension is given, but that extension is not a right virtual by virtue of the tender.
That is why they are.
It's an
being
entry
happy with
management
that,
only.
because you have created this.
That here, in fact, with they have been pleased to in setting up the matter where replies have been filed with regard to the schedule of rate. He is challenging two more clauses, namely 5.6. 5.6 are engaged your lordship's attention in other case where filing of a case was a debarment ground, your lordship has been pleased to strike it down, saying that 5.6 may be for other purpose like blacklisting or debarring other things, but it can't be because you're merely a litigant has filed a litigation. So that can never be. Your lordship has been pleased to explain 5.6. So I think that takes care of. One more thing here challenge is family definition, which has been dealt with in previous tenures. Maybe there is some addition, but copy is given here in court.
But here is a case where participated with this clause.
Yes. So therefore that is there. My lord, copy is given only in court, but I have received instruction to appear and assist. I'll take instruction. My other cases, your lordship has not been.
Take an instruction and then come.
Man.
We will. And go through our judgment where we have interpreted 5.6.
Yes, recently with a very recent order, my lordship.
Go through that.
I'll give that.
and the family, I can say, with respect to the challenge in the family plus.
Please go through that.
Yes, that
Family-
the last year it was challenged.
We'll go into section 28 of the Contract Act, whether it comes to your aid.
And the other part would be that family definition has been dealt with previous years. I'll come back with the authority.
No, it has not been ended.
Anyhow, come calls tomorrow. Another matter.
Man, item
1 week.
15.
Can it be but after that 30th, first week of September, my but there are holidays, 4 days holidays.
So we are
We're on 18th.
25th.
18th.
25th. Come on 25th.
As a lordship.
We give you 1 week time.
May that since I have challenged that without prejudice to my challenge, I can participate. That will
You can always participate without prejudice. That's
Item 15.
You participate. That's all.
Why not it is broadband matter? The difference between NAT PCR and NAT ID. Last time the Honorable Court directed me to produce some scientific papers. Therefore, I am filing a rejoinder today, my lord. Incorporating all the papers. I am sending a copy to the government. I have cited 3 papers, my lord. And I have summarized in para 3, my lord. That conclusion. Phase 2. The hearing process and so the Lordship, this contempt arises out of the order of the Lordship. At the annexure 2, your Lordship, the judgment dated 8/4/2025. Let me see page 23, para 7. How can the contempt lie into Lordship, the judgment of the Honorable Singers has not been modified in the written period. Sitting with Justice Ravre, how can you both can take over it? Has to be taken out of the page. Not sure that how do we explain it? Is all. Because government not is by me and this is of explaining the process. And the list is go to the list as
My lords, I'm appearing for the respondent in the VC matters.
Have filed an IE. If they register company party to the proceedings, that is IA number 4 of 2025. Because he was a party before the court below.
Then let it be.
My lords, my lords.
IA flag C. Flag C.
Number I am unable to find out the IA number. Oh, C.
IA number 4 of 2025 at flag C of my lords.
This is the application.
My lords, may I make a submission, my lords?
Item 21.
My lords, for item 20, my lords, may I make a submission, my lords?
Well, on 21, I appear for petitioner.
No, my lords, only on Thursday because the OL visits this honorable on Thursday. If the matter is on Thursday.
21.
On 21, I bring for the petitioner, my lord. But this is a case under the GST Act, your lordship. The demand in the impugned order, my lord, I am challenging the impugned order, Lecture 1 and Lecture 2, on the ground that out of the total tax demand of 10.46 lakh, I am not required to show an issue so-called notice in respect of tax demand of 9.63 crore as mandated under Section 73(1). So the demand is confirmed to me without requiring me to show cause under Section 73(1). That is why the demand to that extent out of 10.46 crore, 9.63 crore is without jurisdiction. That is my only contention. My lord, if you lordship would kindly see the so-called notice, my lord, the impugned order at page 58, my lord.
At page
58, my lord.
Yes.
There is a table, Your Lordship.
Yes.
In that table, at the bottom, kindly see tax demand of 10.46 crore is confirmed. Out of this 10.46 crore,
Yes.
tax demand of 9.63 crore, which I will show you, Lordship, just now, is there is no show cause notice issued to me requiring me to show cause why this tax not demanded from me as mandated under section 73(1) of the CGST Act. Kindly turn to show cause. This tax demand of 9.63 crore that I am saying, that is out of 3 grounds. That is from 3 grounds, which does not find mention show cause notice. I am not required to show cause as to why this tax not demanded from me. Kindly see, my lord, page show cause notice, page.
Mr. Kurmi.
My lord.
Where from this 9 crores and odd?
I'm showing, my lord. I'm just showing, my lord. My lord, my friend is there in the court, Mr. Panda. I have prepared a chart from different show cause notice, what is there, what is dropped, and how much is confirmed.
Your Lordship, I had a preliminary objection. Your Lordship, objection in this case, Your Lordship, subject to my learning senior's consent. This is the order. Your Lordship, 2 orders have been challenged. One is adjudication order, second is the rectification order. Your Lordship, the adjudication order is on dated 31st August 2024. Your Lordship, without challenging that, Your Lordship, within time, limitation prescribed.
Sir, when has he filed this rectification? Within time?
Rectification has been filed within time. That rectification is for a particular issue of 16.4.
And
that issue.
Mr. Sunil Mishra. The adjudication order was passed. Thereafter, he filed 161 petition or section 161.
Right.
Within time. Then you have considered it on a particular date. You communicated the order. Maybe whole issue or maybe part. And he challenged both the orders. Now.
Your Lordship, what my submission only, so far as the 25-161 order is applicable.
So this is within time.
Your Lordship, that is applicable. Your Lordship, in catena of judgment, Your Lordship, in the meantime has passed that order. 161 order. And so far as the original order, 73, that he may not file appeal or whatever he may be, that may not be adjudicated because the...
You mean to say that 161 is particular issue. Against that he has time.
No,
he has time limit to challenge if at all it is allowed, then need not challenge.
Your Lordship.
But the original issues, certain issues which cropped up in the original assessment, that got time barred. So now he cannot raise it.
Exactly. That
was the original order rectified either partially or wholly?
Wholly, my lord. Kindly see the activation order, my lord, the impure order.
Partially.
Entire ground.
Whatever is grievance in 161, that has been allowed.
Entire ground.
Many issues are in the adjudication order. He has raised only 161 petition, only one ground, that's 16.4. In the meantime, 16.4 has been amended, one section 16 subsection 5 has been introduced. As per section 16.5, he is eligible to get the credit which has been belatedly filed the supplier's return. So accordingly, that has been allowed. Only that is the point in 161. So that has been allowed. He should not have any grievance against 161. Whatever grievance he has raised here, that is against the original adjudication order, and that has been filed belatedly, Your Lordship, this petition. So which may not be maintainable, Your Lordship.
My lord,
this is against 161, and Your Lordship, in the meantime, Your Lordship has passed catena of judgment. Your Lordship, so far as the appeal jurisdiction, Your Lordship may kindly looked into. Even Honorable Supreme Court in Glass, Your Lordship has taken in many cases.
My lord, I'm not
able to challenge, Your Lordship, without jurisdiction, principle of natural justice, and many other, Your Lordship. Only whatever the petitioner can challenge, that can be adjudicated in the jurisdiction, provided that has to be filed within the period of statutory limitation prescribed in the statute, Your Lordship. That is the judgment of Honorable Supreme Court, and Your Lordship, in catena of judgment, Your Lordship, in the meantime has passed.
My lord, may I submit, your lordship?
Yes.
My
He
submission
has
is
raised
that,
a preliminary object, that's why we have permitted him to argue.
that's right, my lord. My lord, that's right. I agree, my lord. Fine, my lord. My lord, my submission is that there is the authorities acquires jurisdiction only upon serving a valid show cause notice upon me. My point is that a valid show cause notice not served upon me, I am never required to show cause as to why that amount of 9.65 crore should not be demanded from me. That is why, without serving a show cause notice on me, the demand cannot be confirmed on me. Therefore, the entire order is without jurisdiction, and therefore it is a nullity. You kindly have a glimpse of section 73. Please have a glimpse of section 73, my lord. Then I will take your lordship to the show cause notice.
Yes.
Yes, Mr. Puri.
My lord, kindly see section 73, my lord. Of the CGST Act, we can see, my lord, it is OGST, CGST is one and same.
No, you have,
So-
you have given that.
You have given a chart.
My lord, from that chart, I am reading your lordship.
No, please consider that there was an assessment order which was submitted on you. It was
That's right.
supplied to you, served upon you,
My lord,
which says that you are liable to pay this much or input tax credit. What is
total after KMABC.
the demand was made to upon you.
25 crores.
Demand was made.
Yes, Lord.
So you could have challenged that particular order ground that it was not preceded by any show cause notice.
My lord, I had
no opportunity of hearing was given, nor an
My lord,
opportunity to defend was given. You
I
could
had
have
two options.
taken that plea. Instead of taking that plea, a order which is per se a nullity, can't you visualize? According to you, the order is per se a nullity.
That's correct, my lord.
Correct? You ask for a rectification of a null order which is per se a nullity under section 161. The author read your contention.
My lord, kindly see the input
Accepted and rectified that order which is per se a nullity. Now, if we go and accept your contention that the order is a nullity without affording an opportunity, then it will impact the whole rectification order which is passed under section 161 as well, where the relief was granted to you.
My lord, let me submit.
Everything will go.
No, my lord.
An order which is void, null and void, that can stand partially.
My submission is very precise, my lord.
Yeah.
In the show cause notice, there were 11 grounds. Please see the chart given, my lord. 11 grounds A to K.
Correct.
Total tax demand in the show cause notice was 25 crores.
So show cause notice was given to you. Now you say.
Yes, I am saying show cause notice was given to me, not respect of the ground on which tax is not confirmed on me. Show cause notice was given to a different ground. Demand is confirmed on a different ground.
Let us see. What do you say?
In the chart, kindly see.
Yes.
Para A to K, total tax demand in show cause notice was 25 crores, 23 lakh, so much, and interest.
Correct.
Out of that, my lord, see, there is a remark also, paid and dropped. So this much after the total, 24 crore, 37 lakh was dropped in the order dated 31st March, August 24.
Correct.
Then the remaining amount came 85 lakh, your lordship. I am not disputing that. Then, my lord, kindly see paras bottom thereafter.
How can it be dropped by an order dated 1/9/2025? The date has not reached as yet.
My lord, I may be wrong in the typing.
Less you see, there are two orders paid and dropped in the order dated 31st of August 2024. I understand. And order dated 1/9/2025. 1/9/2025 has not arrived as yet.
I think there is typical error here also.
It's 9/25.
9/1.
I do not know. You have written 1/9/2025. So I will read that.
No, I'm sorry for that, my lord. It is 1/9. 9/1. 9/1. 9/1, my lord. So, my lord, kindly see, the remaining amount would be 85. If that is so, I would say
85 lakhs.
85 lakhs. I would say there is so cause notice and there is a demand confirmed against me. There is no difficulty. Then 3 more grounds are added, for which there was never required a so cause. These 3 grounds there, my lord. 2 grounds or 2 ground taxes demanded. On the 3rd ground, there is an interest. In the 2 ground, interest also, the penalty is also there. In the 3rd ground, there is no tax, only interest of 1 crore 3 lakh rupees. This is my challenge. I am saying that for these 3 grounds, I was not given a so cause notice requiring me to show cause as per section 73(1) as to why tax should not be wanted from you. There was no specification of the amount in the so cause notice. So the order passed without a so cause notice is a nullity.
That the grounds which is not mentioned in the so cause notice or the allegation which is not there,
my lord,
in the so cause notice, a person should not be penalized because he has not been given an opportunity to defend.
Correct, my lord. Section 73 says.
Have they intimated to you that these are the other grounds?
Yes, my lord, kindly say.
In course of the hearing?
It was given. In the so cause notice, it was there. Kindly see, my lord.
Mr. Kurmi.
My lord.
Perhaps you could not. Whether during the course of proceeding, you were given some intimation or some other notice showing you will be proceeded with respect to those
additional grounds,
additional items or grounds.
My lord, I would say partially yes. Kindly see, my lord. Kindly see. Unless you lordship would see the paragraph, my contention cannot appreciate it, my lord. Kindly see the paragraph.
So that all becomes disputed questions.
Not disputed, my lord.
Yes.
There's no dispute at all. I am on pure question of law. I am not on fact. I am not on fact at all.
They are to be examined by the authority concerned.
No, it is not a question of fact at all. It is pure question of law. I would say simply giving a government, giving a mention without requiring me to show cause as mandated in 73(1), there is no show cause at all. Simply you are writing something, not asking me to show cause as to why this demand should not be raised from you. There is no show cause. Simply one line will come. Supreme Court in the case of metal forging has said that show cause notice must be in a given format. Simply some letter, some communications would not constitute show cause notice. That judgment I will show, my lord. Kindly see, my lord, page 149.
Yes.
I am reading this from so cause notice, my lord. Page 149 at the bottom. This is one of the additional ground that I am claiming that for this there is no so cause to me. It reads, my lord. My lord, I am reading. On examination of the books of accounts furnished before the audit, vis-a-vis the balance sheet, it is ascertained that the tax 29 crores
started 135. Relevant what is places page 149. I'm also
bottom. The heading is verification of material handling charges and outsourcing charges.
Then, my lord, second one at page 150.
No, please continue.
As you have declared rupees 29 point such and such crores under the other expenses as year ending on such and such, and had an outstanding closing balance of 29 point something crores. In this connection, taxpayer has directed to offer its explanation while adducing evidence in support of its defense. and explain whether the ITC has been reserved or not. The reverse.
That is in the part of focus.
In the same invoice through registered mail and taxpayer. The taxpayer failed to furnish the desired information in the prescribed format directed by the audit team. Yes.
This is one, my lord.
Yeah.
Second ground, thereafter, your lordship, kindly see, the taxpayer has clarification on 286 numbers of work orders as revealed from books of accounts. The taxpayer has submitted 283 numbers of work orders in 7 numbers of ARC file on dated so-and-so, wide your reference number so-and-so, dated so-and-so for verification. However, it found that the taxpayer is in agreement with 286 supplier and work orders amounting to rupees 24 crore 19 lakh so-and-so, and which are shown in Annexure 9. In this connection, the taxpayer has been directed to furnish desired information in the specified format pro forma by letter dated so-and-so through registered mail for verification on admissibility of ITC under section 17.5 or Act or in eligibility of ITC under section 16 of the GST Act, which the taxpayer failed to furnish for verification before the undersigned for verification. Third one is, my lord, thereafter, clarification on a statement of ITC reversal due to non-payment under 7 of CGST, SGST rules and its reclaim. In the course of audit, it is submitted that taxpayer has reversed the due to non-payment to supplier within 180 days in periodical return January 21, ITC of rupees 6 crore 86 lakh involving taxable value of 90 crore 57 lakh pertaining to and claimed in tax period 1920 and interest liability of 1 crore 72 lakh.
This is only interest portion.
Please. Please. It is further verified that out of reversed ITC of 6 crore 86 lakh, ITC of 5 crore 21 lakh has been reclaimed in the periodical return GST 3B for the period July 2022. The above discrepancies noticed in the course of tax audit reveals that you have made incorrect self-assessment in the statute return. As such, it warrants proceeding under 73. This is much is there in the SOCAS notice. Now, my lord, kindly see section 73. In the SOCAS notice, this much is only there. Kindly see, my lord, section 73.
Section
73.
Yes. Yes.
Determination of tax not paid or short paid or erroneously refunded or
yes, that's the head note. That's the head note.
I am reading section now, my lord, section 1, where it appears to the proper officer. My lord, allow me to pause for a while.
Yes.
Where it appears to the proper officer means the proper officer has got reason to believe.
Yes.
Where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason other than the reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall, I emphasize, my lord, he shall serve notice on the person chargeable with tax which has not been so paid, or which has been so short paid, or to whom the refund has been erroneously been made, or who has wrongly availed or utilized input as credit. My lord, I emphasize, requiring him to show cause as to why he should not pay the amount specified in the notice. Now, there are two limbs of it. One, there is no specification of the amount in the SOCAS notice. Two, I am never required to show cause, nor there is any contravention alleged against me. What law I have contravened? So there is no SOCAS notice. Now, my lord, kindly turn to. Now, my lord, when I raised this point before the point number 4, he drew his power from subsection 3 and 4. He says that I have jurisdiction. He admits that under 73(1), SOCAS notice is not given to you, but still I have power under 73(3) and 73(4). Kindly see, my lord. 3, my lord, where a notice has been issued for any period under subsection 1. My lord, I'll pause for a while. Means a so cause notice has already been issued. Then this section says what next? The proper officer may serve a statement containing the details of tax not paid, short paid, or erroneously refunded, or input tax credit wrongly availed or utilized for such period other than those covered under section 1. Means for the same period, there cannot be so cause and also a statement. If the so cause notice for 1819, then the statement cannot be for 1819. It may be for subsequent period other than those covered in section 1 on the person chargeable with tax. Then 4, my lord, the service of such statement shall be deemed to be service of notice on such person under section 1, subject to the condition that the grounds relied upon for such tax period other than those covered under section 1 are the same as are mentioned in the earlier notice. So in the notice, there is no ground at all. So no correspondence, no statement can come to the rescue. There has to be a so cause notice first. Once a so cause notice issued, at ground, if the department wants to issue second so cause notice, he can issue a statement. But when so cause notice is not at all issued, question of 3 and 4 will not come. By invoking 3 and 4, the point number 4 accepts the 73(1) is not complied.
Sir, what do you want to say when you are referring us to this provision? These are really, according to you, are the statement without having preceded by any so cause notice. So what you read about the verification of a trade, the trade payable, verification of the material handling charges, outsourcing, and then the clarification on the statement, 268 6 numbers of work orders as revealed. All these were the statement which they made because during the audit exercise, they found several discrepancies and their verification was asked for, which you grossly suppressed and did not give. So that was the statement. They say that means the statement which lead to an initiation of the proceeding against you. According to you, these are simpliciter in statement, and there is no tax shown which you are required to pay.
As under 73(1).
As 73(1). So there is no show cause notice.
That's right.
It cannot be perceived. This is what you wanted to say.
That's my submission, my lord.
Page 227.
Yes.
Your Lordship, this adjudication proceeding is not simply a proceeding under section 73. It is pursuant to, as your Lordship rightly pointed out, pursuant to audit. The audit report started from serial number 191 page, and these two issues, your Lordship, for a moment may kindly turn to page 227. For a moment.
You have say that you have quantified.
No. The petitioner himself in the audit process has participated and not produced any evidences on these particular two issues, your Lordship. For that reason, at page 227, the audit officer himself says, on examination of books of accounts furnished before the audit and the it is ascertained the taxpayer has declared rupees 29 so under the other expenses. In this connection, the taxpayer has been directed to offer its explanation while adducing evidence in support of its defense and explain whether ITC has been reversed or not on the same invoice registered mail, and the taxpayer acknowledged the same, whereas the taxpayer failed to furnish the desired information in the prescribed format directed by audit team by letter number so dated so. Hence, verification may be done at the time of adjudication level. Your Lordship, these two issues, your Lordship, have been relegated to the adjudication as per section 65, subsection 7, for proceeding, for initiation of proceeding, section 74. Your Lordship, not only these two issues are page 228, revenue para number 1, 3, 4, 5, 6, 7, 8, 10, 11, 12, 13. all are to be adjudicated accordingly. Your Lordship, the show cause notice has been issued and adjudication has been made. Nowhere, Your Lordship, neither in the adjudication nor in the rectification, whatever the quantification has been made in the show cause notice has been enhanced, Your Lordship, what the assessing officer cannot do. Your Lordship, that is well within, first that is 39 crores, subsequently reduced by 46 crores. In the show cause notice, the amount was, Your Lordship, the amount was 46 crores. In the adjudication, that has been reduced to 39 crores, and in the 161 proceeding, that has been reduced to 22 crores. Tax interest penalty. And as far as the interest levy is concerned, the reversal has been allowed and subsequently it has been reversed. As per section 50, it is automatic, the interest. For that reason, even no show cause is required, particularly for levy. At any time, Your Lordship, interest can be levied under section 50 because that is admitted interest, so far as the delay in filing of the return or delay in filing of paying the payment of the tax. So the adjudication proceeding is detailed. It is a, Your Lordship, so far as that AVR is a detailed AVR is there, Your Lordship, but due to his non-submission, only these two issues could not be adjudicated in the AVR and rightly adjudicated in the assessment proceeding, Your Lordship. So hence, by responsible submission, so far as the rectification application, Your Lordship, that has been allowed so far as the 16.5. If he wants to file, let him file appeal, Your Lordship, and so far as the adjudication proceeding, Your Lordship, it is since it is delay, Your Lordship, may not grant any liberty so far as the filing of appeal is concerned, Your Lordship.
Relief is barred.
Your Lordship.
Relief is barred.
Your Lordship. But Your Lordship has decided in so many cases, Your Lordship, and I have submitted all the charges.
The entire order of 31st August is reproduced in the impugned order of 9 January. Entire order is reproduced.
Your Lordship, for a moment, Your Lordship,
Entire order.
look at the 161.
And then the figure has been reworked.
What was found in 161?
Come tomorrow, I will see to it.
Your Lordship.
D'accord.
The rest of the matters will, 36 is an urgent matter.
Let us see.
Wanted to withdraw.
Which one?
Item 55. Order.
You want to withdraw?
My lord.
55, who is appearing?
These cases are not registered.
Oh, these cases are not?
Registered. The number of cases.
So,
people lordship for the.
it's withdrawn. Who is appearing? What fresh matter? This is what it has to be done. He wanted to withdraw, he will withdraw.